on Friday, on Thursday, your lordships will not desired what happened to other assimilation of other states. Lord, during the weekend, my lord, we have undertaken that exercise. The documents were available in the National Archives, and the officials of the Home Ministry went in National Archives. They studied everything, and we have prepared a 2-page note for that. My lord, if your lordship allows, I can, my lord, immediately share it with others, my lord, and
what you can do, it since it was in response to a question of the court, you can just ask the nodal council to make it a part of your submissions as an annexure, so it won't get misplaced.
correct.
Make sure and circulate to the other side as well.
My lord, right now, would your lordships like to?
Yes, yes, we can see it right away, no problem.
No, I'll just, my lord, kindly allow me to send the mail. It is sent.
Miller?
It won't take more than, my lord, it is sent. And the other side.
Yeah, our whole line, there was no.
It's in fact a 1-page note, my lord, not even. Rest is, my lord, list of states. So we need not read the list. The figures would matter, my lord, not the names.
In the meantime, if you have it for my colleagues on the.
My lord, can I be permitted to circulate?
Yes, no difficulty. We'll see it. Because it'll take a few minutes to otherwise come on the email.
One more. One more. One, I have already said this is from National Archives, coupled with, my lord, facts stated in the white paper. I'm sorry, my lord, my lords.
Now there on all the members of the bar will also get it on your screens in front of you. Actually,
it is now received. It is received.
It's now on the screens for everybody. Yes.
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 First is, my lord, we have said that this is combination of our research in the National Archives and white paper. Second, at the outset, it is necessary to clarify that the process of integration of princely states with Dominion of India and or Union of India was not a linear process. The merger agreements and instruments of accession, along with proclamations, did not operate in a step-by-step manner for every state. They represented various means of integration of princely states with the country. The signing of either of instrument of accession or revised instrument of accession or merger agreement or even a proclamation only, like Hyderabad state, is sufficient for integration with Union of India. Therefore, the list of princely states which fall under merger agreements are separate from the list of princely states which are covered with instruments of accession or revised instruments of accession. Therefore, broadly, there are two heads: princely states falling under merger agreements and princely states falling under instruments of accession, followed by proclamation. Under the first head, princely states falling under merger agreements, the princely states were of two kinds. A, princely states with merge with the existing Indian provinces, they were British controlled provinces. And second, princely state with merge with states as centrally administered areas. Lord, some of the princely states desired that we should be directly governed. Some of them, Lord, were strategically so located that
they became the chief commissioners.
Chief commissioners provinces, your lordship, sir. The next category of princely states, this is important. Table C are the ones covered by the instrument of accession, revised instruments of accession, followed by proclamations. The distinction between the two is of terminology and not a step-by-step linear process, as a large number of states directly signed revised instrument of accession without signing the pro forma instrument of accession before that. Therefore, the same is being clubbed and expressed as table C. Princely states covered by instrument of accession or revised instrument of accession and proclamation accepting Indian Constitution. It may be noted, to the limited position emanating from the National Archives and white paper, that these princely states did not sign any merger agreement. Lord, then your lordships would come to the next page. Lord, 1 to page 1 is, my lord, 1 to 32, then 33 to 65, then, my lord, 66 to 77. The lordships have, my lord. The rest is not available. Lord, please see, my lord, the states from Balasinore to Surgana were a part of one group which had a total of 144 states. They formed their own group. Therefore, my lord, they are 77 to 144. Then, my lord, total comes to 204. So we have started with 205. It goes up to 216. Then provincially merged Khasi states. Khasi states were essentially in the northeast, and, my lord, they are 241. Total, my lord, are 241. Then, if your lordship turns the page, this is table B. Princely states which were merged with states as centrally administered areas. Then, my lord, we have started with 242. It goes up to 302. We need not, my lord, read the names. These were, my lord, the states which were centrally notified areas. Now, my lords, may kindly come to para 7 at the foot. It is to be noted that the above agreements were signed by the Secretary, Department of States, Government of India. On signing of these merger agreements, orders under the relevant provisions of the Government of India Act were issued, giving legal force to these agreements. Then, my lord, table C. Princely states covered by instrument of accession or revised instrument of accession and proclamation, accepting Indian Constitution, no merger agreements. These are, there were several states which did not sign merger agreements. My lord, which we have started from 303, taking, my lord, the list from 302 on the earlier para, and it goes on till 580. So it is 555 plus 24, because Khasi states are separately dealt with even in the white paper. Therefore, my lord, this is the total figure which became a part of Union of India when Article 1 came into force. And, my lord, we have given the disclaimer that, of course, this is based on National Archives and the white paper. But, my lord, as a matter of interest, my lord, the National Archives, my lord, the officers, my lord, the Joint Secretary and others who went, well, it's worth visiting. It's very well maintained National Archives. My lord, in some of the documents, you need to maintain a particular temperature so that the document is not destroyed. My lord, every care is taken since beginning. As an interest also, your lordships may not consider once visiting it, not for this matter, but there are several historical documents, several films, not, my lord, as we understand, my lord, that some of the documents are filmed and they are preserved. Some of the speeches of our national leaders, my lord, whichever could be videographed in those days, are very well preserved. There are several maps and many, my lord, matters of historical interest. But the beauty is that since the beginning of the country, it has been preserved well.
Yes.
My lord, I was at page 47, my lord. And whatever is irrelevant, your lordships may, my lord, take it from me. Again, I have, my lord, diluted. and I will not take much time, my lord. Whatever may be relevant to be put here as a completion of chronology, I have put it, I will not read it, my lord. Page 47, my lord. Now, my lord, this is after India attains independence and the constitution is adopted. My lord, constitution is adopted, my lord, we are aware, my lord, 26th of January, 49. 26th November, 49. I'll just check up, my lord. Our impression is subject to verification. Article 1 came on that very day. From the beginning, Article 1 is there, subject to, my lord, verification. Lord, page 47, CO 10.
Yes.
I'll just orally point out what it contained two aspects. My lords are aware, my lord, Article 371A, which provided that first take the list of 3 entries which the instrument of accession maintained, that is defense, communication, etc. And the president was to find out which are the corresponding entries in the union list. Because defense can have 5 corresponding entries, communication can have wireless, telephone, etc. 5. So, my lord, first act, my lord, which I have mentioned is that, my lord, with which your lordships may directly not be concerned, just by way of, my lord, an example that the Honorable President, by this first CO, identified the entries, that these entries would fall within those 3 broad subjects which the ruler has given under the instrument of accession. Then it is exercise of powers under 371D and applying these provisions of the Constitution of India. Your lordships would find, I'm not reading union, relations between union and states, but all were applied with modifications. As Article 370 or itself, Lord, points out, for example, amendment of the Constitution. 368 was applied, but with a provision in sub-article 6 that any amendment made in the Indian Constitution would not ipso facto apply to the Jammu and Kashmir.
You follow the Article 370 route.
Unless, yes, unless applied through Article 37. So, my lord, in that fashion, Lord, the second part of this CO 10 is,
the first part was with consultation, the second part was with concurrence.
With my lord, concurrence. Concurrence, my lord, consultation is only qua.
As far as 368 is concerned, the constitution can be amended in terms of that article by the parliament and so forth. Now, as far as proviso to 368, it says that the legislative assembly can then adopt, or with concurrence, then it will apply over. Whereas D requires concurrence. Concurrence probably will be prior concurrence.
My lord, that would be so.
Because when we are talking about constitution as it exists, 371D refers to the constitution as it was originally enacted.
Yeah.
368 refers to the amendments to thereafter.
Yeah,
so there is a slight difference between the two.
Yes, so whatever amendment is made in any part of the Constitution would not apply unless it is so applied either fully or with modification and exception under 371D route.
It will be 371D route or 368 route?
No, it would be 371D route. So I'll tell you, Lordship, why. Lord, suppose the Indian Parliament amends.
Some audio ways.
For that.
38 is not in this red book, no?
No, it is now deleted.
No, but the red book has a lot of other things, but some of the others not there.
But would your lordships like to see, my lord, the original the CO? Lord, that your lordships would find
it should be here actually.
Volume 3. Lord, let us take a hypothetical illustration, Manoj. Just, my lord, to
It's just a matter of logics, that's all.
Yes,
Because if-
only 2 minutes, my lord. The concerned amendment, my lord, in this CO is at page 4 and 9, 4 to 9, in volume 3,
Volume 3, right?
CCD. Please come to, my lord, page 8, my lord. The directly, my lord, page 8. And I'll give one illustration only, my lord, at the foot, my lord. Your lordships have, my lord, 360, my lord, part 12, part Roman 12. I'm sorry, part Roman 20. My apologies. Part Roman 20. my lord.
Which page are you?
Page 8, volume 3, the document volume 3, PDF page 8. This is, my lord, the concerned CO 10.
Unless applied by order of the president and a clause.
Provided, I'm sorry.
Yes,
My
we
lord
got it.
Justice Khanna gets me.
Page
Provided the proviso article 368 shall apply subject to the additional proviso, provided further that no such amendment shall have
Just
effect.
1 second. One.
This talks back to article.
Yes, my lord, I'll just give an illustration.
It says.
Yes,
371.
my lord, just to illustrate, my lord, for example, Constitution of India amended and inserted Article 21A, right to education, free education, etc. It never applied to Jammu and Kashmir till 2019 because this route was never followed.
Likewise, as you said, the preamble amendment of 1976
Was
what is it?
applied with modifications, etc.
So the secularism and socialism amendment was never adopted in the case of
Yes.
Jammu.
Yes, even integrity word is not there.
Right.
That was also not applied.
We can skip this now. We can go ahead.
Yes. Lord, Lord, this is contemporaneous. Your lordships would find the date. It is 26th of January, 1950. So contemporaneous, nothing, my lord, much turns on that. Your lordships may, my lord, directly come to page 49.
Page 49 of the same volume.
Of my written submission. I'm sorry, my written submissions. Lord, it is respondent conjoint written submissions.
Yes.
Written submission, volume 3, my lord. Lord, 1st May, your lordship gets the date. My lord, the Chief Justice gets it. 1st May 1951, Yuvraj Karan Singh issued a proclamation directing the establishment of an elected constituent assembly to draft a constitution for the state of Jammu and Kashmir. Please don't read the note, my lord. I'll orally point out what it says. Lord, when I take your lordships to the position of Jammu Kashmir Assembly vis-a-vis our constitution, my lord, the Constitution of India and the Constituent Assembly of India, Lord, I read that proclamation just to show that it was intended to be subservient to and subordinate to the Constitution of India. But right now, this is a date that the Constitution.
Mr. Solicitor, you may deal with this, what I'm suggesting, but I'll forget it. So, I was reading a list of dates in the morning, the thought struck me.
Yes.
At one level, you may be right, or subject, of course, to what we have to consider on the rejoinder, that your argument is that the Constitution for the Republic of India is really a document which lies on a higher platform than, say, the Constitution of the state of Jammu and Kashmir. That J&K Constitution, according to you, is subordinate to the Union Constitution. That's one aspect. The second aspect, which you have tried to make out in your note, which we may elaborate it upon it later, which is your contention that, look, the Constituent Assembly of J&K was in the nature of a legislative assembly and not a constituent assembly. That, strictly speaking, that there may be a problem for two reasons. That's not how Article 372, bracket 2 refers to it. It refers to it as a constituent assembly of the state.
Correct.
But more important, once Article 238 made certain provisions of the Constitution inapplicable to the Part 3 states, and particularly the state of Jammu and Kashmir, including executive, legislature, judiciary, which would be brought into force by the Constituent Assembly framing a constitution for the state of Jammu and Kashmir, then it may be very difficult to call it a purely just a legislative assembly. That is an aspect which you may want to deal with. You may deal with it in just one
Because that
sentence,
is
and
a
then maybe
separate segment, my lord, of my subject.
then we will deal with it at that
I-
point.
I'm
on the
obliged.
list of days.
I'm obliged. My lord, rest of the 3 dates your lordships can, my lord, ignore. Kindly come to page, no, not ignore, my lord, skip. Sorry, my lord.
And we have read Sheikh Abdullah's address was read out to us by the other side. So we
I'm not
need
reading, my lord, any address now. I'm just on the chronology,
Yes,
and
yes.
chronology which is relevant right now.
Absolutely, you
Which
can
would,
go.
rest
Yes, yes.
is, my lord, for completion, but may not, my lord, invest your lordship's time. Then, my lord, Constituent Assembly is created. Now, my lord, comes CO 39, that is 1952 CO. Lord, please see, under Article 371, Lord, these are all appears to be, my lord, powers under 371D, but all COs mention it as 371. Maybe making a little broad source of power of the Constitution of India. In following consultation with the government of Jammu and Kashmir, the President issued the so-and-so order 1952, modifying Article 54 and 55 of the Constitution insofar as it applied to the state of Jammu and Kashmir. By this CO, for the first time, President recognized the Constituent Assembly as the Legislative Assembly for the purpose of election of the President of India. Your Lordships would, my lord, note, when Constituent Assembly of Jammu and Kashmir was formed, obviously there was no Legislative Assembly because that was yet to be a part of the Constitution to be framed. So as to ensure that they do not lose their representation in election of the President, Lord, this CO was issued that you will be treated as Legislative Assembly also. Lord, your Lordships would find at the end of this chronology, 370 has been applied in kind of a floating way. Whenever, my lord, it is required to use the word interchangeably, it is logically so used. And whenever any word has become OTOs, it is replaced by its successor. Look, this
At that point, there was no legislative assembly at all.
at all, correct. I say
Therefore, they had to make this CO
correct.
to read that instead of the word legislative assembly shall also include a reference to constituent assembly. Because at that point, there was no legislative assembly.
My lord, exactly that is where, my lord, I would respectfully drive it. When there is no legislative assembly, the constituent assembly, the president has said that now it would be treated as legislative assembly. But that I'll come little later. But it has been used, my lord, kindly see there are two, my lord, prominent features in COs which comes up.
Yes.
A, it has been used in a floating way, some words used interchangeably. And second, and most important for my purpose, whenever a word in Article 370 becomes OTOs for that post not being in existence, that body not being in existence, it is immediately replaced by its successor. Sadr-e Riyasat is replaced by governor, etc. Now, my lord, your lordships may come to the next date, 20th of June, 5th. There was a letter, my lord, referred to by Mr. Gopal Shankar Narayan, where Dr. Rajendra Prasad, the then Honorable President of India, writes to the Prime Minister, Honorable Prime Minister Nehruji, that this can be used only once, etc. That is being used, that can be used, my lord, in buttressing the arguments which I am also advancing. But we also got, my lord, the response of the Honorable Prime Minister. I'll put it, my lord, when that fact comes, my lord. And thereafter, the same Honorable President issued, my lord, order under 370 sub Article 3 also. So, my lord, literally, actions speaks louder than words. That was, my lord, the understanding, but the understanding was that it is so drastic a provision that use it only once. It's an self-extinguishing provision. That's my lord, the tenor of that later. My lord, while the Constituent Assembly of Jammu and Kashmir was in session, Lok Sabha also continued its session. In New Delhi, as per Constitution of India, during one of the Lok Sabha debates, Lord, please see, my lord, how our parliament understood Article 370. Lord, the purpose is to satisfy your lordships that Article 370 is not just stated to be temporary. Legislative Assembly debate says it is temporary. Even during the subsequent parliamentary procedure also, everyone treated it as a temporary measure. But only for that, this is N.C. Chatterjee. But incidentally, he was the counsel in Premnath Kaul judgment. N.C. Chatterjee, he must be a member of parliament also. I'll just read the underlined portion. I maintain and I say that with all earnestness that under the law, under Constitution, accession to the dominion of India under Section 6 of the Government of India Act, as amended after the Indian Independence Act, was final and irrevocable, and there ought not to have been any question of plebiscite. I maintain that accession is final and irrevocable. Under our Constitution too, Kashmir is an integral part of India. Under Article 1, the Indian Constitution consists of Federation of States and it is a Part B state. There cannot be any going back on that. But the unfortunate thing is that the Constituent Assembly is doing something there which is against the spirit of our Constitution. I know my honorable and learned friend Dr. Kaju will point to me Article 370 of the Constitution. Article 370 is part of Chapter 1221 and it deals with temporary and transitional provisions. Then, Dr. Mukherjee, in a democratic federal state, the fundamental rights of citizens of one constituent unit cannot vary vis-a-vis the citizens of another unit. Are not people of Jammu and Kashmir entitled to the fundamental rights that we have given to the people of India minus Jammu and Kashmir? There is no scope for varied constitutional patterns, disparities as between one federating unit and another. The legislative or executive authority of the units in respect of the states will be coextensive with the similar authority in and over the provinces to certain adjustment during the transitional period, the fiscal relationship, etc. Then, my lord, Pandit Ji, as the Prime Minister and Minister of External Affairs, Lord, responds. So, Kashmir obviously is a constituent unit of the Federation of Union of India, but a difference has arisen, subsequently arisen. You please remember that, not originally, between Kashmir and other states, because subsequent to the earlier accession, the other states have become integrated, more which Kashmir has not and could not in the circumstances as I have tried to point out. But nevertheless, it is a full constituent unit of India. Various things flow from it. Various consequences. Consequences, for instance, in regard to the President of the Republic. The President has certain authority which he exercises on behalf of Republic, and wherever the constituent unit may be, the President will exercise that authority in that measure. But come to the last line. But the President's ultimate right has to remain for a constituent unit of India. That irrespective of 370, the President of India's right, which he exercises on behalf of the Republic, which he exercises on behalf of we the people of India, must remain as a plenary power without any fetters. My lord, that's how the Parliament understood. My lord, thereafter, my lord, your lordships would come to, my lord, page 52. First 2 days, dates your lordships may skip. My lord, during the Jammu and Kashmir Constituent Assembly debates also, my lord, I have quoted, but I may, my lord, just paraphrase it and proceed further. Lord, it says, every member says that this is temporary. They also understood it to be temporary. Lord, I am not laboring on the point right now why it is temporary. The point is, which I will ultimately make, despite full knowledge that Article 370 is a part of the Constitution, despite having accepted in the Constituent Assembly debates of Jammu and Kashmir that it is temporary, they chose not to make any recommendation under sub-article 3. My Lord, that's a separate limb, and I'm just flagging it here. Kindly see, my Lord, highlighted part. This assembly came into being because of section 370 of the Indian Constitution, and it was because of the section that we enacted such laws as were necessary for our society. So, my Lord, they understand that its very source of existence was Constitution of India. Lord, kindly come to page 53, third. Lord, this is third date, 15/11/52. Lord, this was the first use of Article 370, sub-article 3. So kindly note this.
Yes.
Yes, my Lord, kindly allow me, my Lord, to point out, my Lord, this might appear to be striking because it is striking. It should never have been at the first given and should never have been continued. The effect of 370 with 367 or any provision of the Constitution is that by an administrative act of the Honorable President and the Government of the state, any part of the Constitution can be amended, can be altered, can even be destroyed and not applied, and new provisions can even be created in Constitution of India. 35A, I'll come to it. Article 35A was created, which is a part of Constitution of India, only to be applied to the state of Jammu and Kashmir. That's why, my Lord, this 371 route and 367 mechanism has been used more than once because 370 permits it. It stopped, my Lord, only after 5th of August 2019. Otherwise, any provision, any article, my Lord, it was placed much at a higher pedestal, as my Lord Justice Call rightly pointed out, than even a basic structure. Please see, my Lord. Constitution application to Jammu and Kashmir, Order 52, was issued by way of the state presidential order issued under Article 3701D. The first exercise is 3701D. The term Raj Pramukh, used anywhere in the Constitution of India, Jammu and Kashmir being a Part B state, was replaced by Sadari Riyasat of Jammu and Kashmir. My Lord, because in Jammu and Kashmir, Raj Pramukh was not there, Sadri Riyasat was there. So wherever one authority ceased to exist, it was replaced by the successor authority. Now the second part which is done, similarly, with a CO 44, there are two COs, my Lord. Explanation to clause 1 to Article 370 was modified by the President in exercise of his powers under Article 370, sub-article 3, on the recommendation of the Constituent Assembly. Lord, because there, at that point of time, Constituent Assembly was in existence. So the proviso to sub-article 3 could be operated. Therefore, it was so recommended, and the President added these words: the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as Sadri Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in force. Well, the purpose of pointing out is that 370 has continuously been evolved depending upon the need of that situation at the point of time. Earlier, it was Maharaja. Since Maharaja ceased to exist and Sadr Riyasat came, it was modified using 370 sub-article 3. And since Constituent Assembly happened to be functioning, it was with recommend. I'm sorry. Now, your Lordships may kindly come to page 54. CO 48, Lord, that is 14th May 54. Lord, several other provisions were applied, but your Lordships may right now only mark fundamental rights. How it was applied is really shocking, and I'm using that word consciously. But what was not applied is also interesting at the foot of page 54, which continued not to apply till 5th of August 2019. That is, my lord, at the foot your lordship gets, my lord, notably. I'm sorry, but I am on page 54. My lord Justice Khanna may see.
Yeah, I've got it.
Lord, fundamental rights just mark that they were applied. But what was not applied, notably, it did not apply the following parts at all. That is, directive principles of state policy, the states in part B, and scheduled and tribal areas. Tribal areas and any tribal reservation, etc., never applied in the state of Jammu and Kashmir till 2019. Now, the preamble was applied. My lord, your lordships are aware, preamble is not treated to be a part of the constitution, and therefore, my lord, it is separately applied. I am not repeating. The word socialist and secular was not applied. Of course, they have put it in the directive principles. But directive principles are amendable by legislature. Your lordships are on page 50.
Yes.
Lord, kindly come to foot of page 55, because this, according to me, Lord, as a student of law and as a citizen also, Lord, is something very, very serious. Other notable features, my lord, by this CO, what was done? It provided for a separate provision for permanent residents of Jammu and Kashmir in Article 7. That is, my lord, citizenship of Indian Constitution, by inserting 35A.
Yes.
Then it removed references to scheduled tribes from Article 15, sub-Article 4. So, one, you alienate those who do not fall within the artificially created definition of permanent residence. Second, you alienate those who belong to scheduled tribe. Then, this is important, Article 19, 22, 31, 31A and 32 were applied with some modifications. and I'll show which modification. Surprisingly, in Article 19, please note this, my lord, this is something really shocking. And for 25 years, this continued. I am arguing this matter not from the point of view of center succeeding or state succeeding. How 370 operated on the people of Jammu and Kashmir because of 370. That's what, my lord, my attempt is. Surprisingly, in Article, I'm sorry.
Yes.
Surprisingly, in Article 19, the following sub-article 7 was added by way of modification which remained till 1979, for 25 years. And what was that?
Yes.
Article 19, sub-article 7, as applicable to the state of Jammu and Kashmir, the words reasonable restrictions occurring in clause 2, 3, 4, and 5 shall be construed as meaning such restrictions as the appropriate legislature deems reasonable. Lord, the citizens apply fundamental rights against the state, and now the legislature would decide what are the reasonable restrictions.
Other provisions of Part 3 were applied without any modification.
There is a modification.
35C is there.
35C, my lord, and that is more draconian, my lord, if I am permitted to say so. Because that directly affected the personal liberty of the entire population of Jammu and Kashmir.
Preventive detention.
Preventive detention. 21 and 22 would not apply. But it's unthinkable in any constitutionally governed civilized society that Article 21 and 22 would not apply. Please see, my lord, Article 35C was added. Our India's constitution was amended by the government of India in consultation with the state government, adding this sub-article. Lord, see, no law with respect to preventive detention made by the legislature of the state of Jammu and Kashmir, whether before or after the commencement of the Constitution Order 1954, shall be void on the ground that it is inconsistent with any of the provisions of this part, but any such law shall, to the extent of such inconsistency, cease to have effect on the expiration of 5 years from the commencement of the said order, except as respects things done or omitted to be done before. Lord, this 5 years became 10 and thereafter it became 15. It continued till 1974. And my lord, most interesting part which I found,
Mr. Solicitor, you are appearing for the government of India, which did all this.
yes, my lord, I'm saying.
In constitutional theory, the government of India
Government of India
is a perpetual
is
entity.
succession. My lord, the government of India has a right to say that this ought not to have been done and correct itself, which we did, and I'm justifying that correction. So I'm not saying that government and this government. It's our government.
Because in constitutional doctrine, the government of India is one perpetual entity.
Perpetual entity with perpetual succession, my lord. Yeah. And therefore, my lord, the justification, my lord, which I am trying to give is that the mistake of past should not befall on the future generations. And that's why what we did in those days, I am justifying, my lord, I am justifying our undoing it in 2019. Yes. My lord, one very interesting angle I found out, my lord, while researching this on this question. My lord, in Premnath call, some person was, Mr. Kaul was, Premnath Kaul was detained under preventive detention law. He approached this honorable court under Article 32, challenging his detention. The learned Attorney General, then, my lord, appearing for the government, took the contention that 32 petition is not maintainable because it would lie only for violation of fundamental rights, and for Jammu and Kashmir, Article 21 and 22 are not fundamental rights. Fortunately, my lord, the court did not go into that question and decided it on merits. I'm sorry, Sampath Prakash, not Premnath. That was, my lord, the position of the 35C. Fundamental rights, your lordships have said 21, 22 is the heart and soul of the entire chapter 3. That was not applicable. It could be dispensed with while making a law for detention. Then, my lord, 35A was added. Please come to, my lord, page 56. And this, my lord, if we were to believe, resulted in several consequences. Please see 35A, amended in Constitution of India only to be applied in one state of Jammu and Kashmir. Please see, madam. One artificial class was created. Notwithstanding anything contained in this constitution, that is Constitution of India, no existing law in force in the state of Jammu and Kashmir, and no law hereafter enacted by the legislature of the state defining the classes of persons who are or shall be permanent residents of the state of Jammu and Kashmir, or conferring on such permanent residents any special rights and privileges, or imposing upon other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or right to scholarship and such other forms of aid of the state government may provide shall be void on the ground that it is inconsistent or which with or inconsistent with or takes away or abridges any right conferred on the citizens of India by any provision of this part. A separate category of permanent residents was created, and any law which provides for this kind of special privileges would not be hit either by Article 14, Article 19, or any part of the Constitution. And that demarcating line from which date a person should be treated to be a permanent resident was, I think, 35. Yeah. Who's
35A challenged on the ground that it violates the basic
The
structure?
35A, it is, there are 5 petitions pending with
No,
them.
but that's, before that, it was never challenged.
They were challenged at the relevant point of time, could never be decided. I think, since long. Lord, kindly see, my lord, the impact of this. The cutoff date was, my lord, I am told 1927. So whoever came in Jammu and Kashmir in 1927 were permanent.
That's the law, what is the provision itself? It says it not, the judicial scrutiny is therefore prevented because
Now, the impact was, for example, people from Jammu and Kashmir, people from Pak occupied Jammu and Kashmir, Pak occupied Kashmir, POK, were driven out, both Hindus and Muslims. But they were driven out in 47 during those raids. They are not permanent residents. They were not permanent residents till 2019. There were large number of Safai Karmacharis who have filed a petition, my lord, or intervention application, who were brought from other states to do, my lord, the manual work of cleanliness, etc. They are not permanent residents. They are not getting any of these benefits. Despite living for decades together, no person, my lord, beyond outside Jammu and Kashmir can acquire property, meaning thereby no investment.
So from this point of view,
Yes.
I was just looking at the 1954 order, CO 48,
Yes.
that applied the entirety of Part 3
Yes.
and then made certain modifications. Therefore, Article 16 applied, Article 19 applied. But now see what happens. If you look at the CO, it applies Part 3. That is Volume 3. You get it at Volume 3, page
14 months.
page 14.
Yes.
Volume 3, page 14. But you bring in Article 350, Article 35A, which creates an exception in 3 areas. Employment under the state government, 2, acquisition of immovable property, 3, settlement in the state, leave aside scholarships. So though Part 3 is made applicable, by the same vein, when you introduce Article 35A, you are taking away the 3 rights, 3 fundamental rights. 16(1), 19,
14.
and 16(1), then you are taking away the right to acquire immovable property, which then was a fundamental right under 19(1)(f) and Article 31. And third, settlement in the state, which is a fundamental right under 19(1)(e).
Right.
So though the Constitution expressly made the provisions of Article 19 applicable, which would include these 3 rights, and Article 16, by enacting 35A, you virtually took away the fundamental rights.
Employment is also right to life.
Right, but there's a direct right under 16(1).
Yes. No, employment is a separate right and would fall within separate category of right to life.
No, that itself was not taken away. What was taken away was employment under the state government. Because what 35A did was, it says conferring on such permanent residents any special rights and privileges or imposing upon any other persons, any restrictions. So it does both things. You can give special rights to residents and you can take away that right insofar as non-residents are concerned. Employment under the state government. Employment under the state government is expressly covered by Article 16(1), because 16(1) says there shall be equality of opportunity for all citizens in matters relating to employment under the state. That includes the union as well as the states. So while on the one hand, Article 16(1) was preserved, 35A directly took away that fundamental right and granted immunity to any challenge on the ground that it would deprive you of a fundamental right which is protected by 16. Likewise, 19. 19 recognizes the right to reside, settle in any part of the country.
Right to acquire property.
And then, property then was 19.
Now it is 300.
So all 3 fundamental rights were essentially taken away by 35A, which was brought in by CO 48.
It continued till 2019.
Power of judicial review was taken away.
Judicial review was taken. So it is beyond 9th schedule. Almost put at par, beyond 9th schedule also. And this continued till 2019, till the impugned resolution, impugned CO was passed. Therefore, my lord, I am respectfully urging that please look at the matter from the point of view of people of Jammu and Kashmir. Something which is impugned before your lordships is a constitutional exercise of power which confers fundamental rights, which applies the entire constitution, which brings the Jammu and Kashmir people at par with their rest of brothers and sisters, and Lord applies all laws which are welfare legislations, and I have the list which was not applicable to the state of Jammu and Kashmir. And the very unfortunate part is, and this is really, my lord, a troubling part, that till now the people were convinced by those, my lord, who were supposed to guide them, that this is not a hindrance in your progress. This is your privilege. You fight. Nobody can take away 370 from you. That is the most unfortunate part. And your lordships have, my lord, at least 2 major political, I'm not being political, major political parties before your lordships defending 370, including 35A. When your lordships ask, what did you lose out of it? There is no list. This is what the people rightly lost. They got their fundamental right 35A goes. They got their fundamental right 35C goes. And I will come to, my lord, several other, my lord, provisions which were working against the interest of the people, but they were convinced. Now they have realized what they have lost. Because now, because of 35A not being there, investments are coming. Now, because of, my lord, the law, I'll show, my lord, from the Reorganization Act, because of the policing being now with the center, my lord, tourism has started. Jammu and Kashmir traditionally didn't have much of big industries. They were cottage industries, small industries, etc. Main, Lord, the source of income was tourism. Now tourism has started. By now, Lord, 16 lakhs tourists have come. New hotels are coming up, which gives employment generations for the two large number of people, right from Tangawala to Lord, officials. I'll come to that. So
In a manner of speaking, 35A is not a modification of Article 35. It is a creation of a new article in the Constitution. That's where I'll make this assertion.
The
It's
scope,
not a modification at all.
the scope of expression, exceptions and modifications
That's right.
will also.
So virtually you created a new article in the
A
Constitution.
new provision.
That's right. It's not a modification.
it's not a modification. Therefore, I respectfully urge 35A is creating a new provision in Constitution of India only to be applied to Jammu and Kashmir. Now, my lord, if a lady marries outside Jammu and Kashmir, she loses permanent residency. There are several such things, my lord. People coming from West Pakistan who were, my lord, settled down from decades were not.
The first part was struck down by a 3 judges bench of the J&K High Court.
By the High Court, my lord. I'm sorry, I was not aware of
The
it.
difference of view, 3 judges bench.
There, I'm told that children will not get. So whatever, my lord, that's now.
Who does say children will not get it? It was a nebulous situation which will get. That's all.
Now, my lord, kindly come to page 57. And my lord, the argument was that why did you not consult ABCD? My lord, out of ABCD, ABC is proclaiming that 370 is our right. Official, that's the official stand. So leave it at that. Please come to page 57. Now, my lord, use of mechanism under Article 367 for the interpretation of Article 370 for the first time. But any provision of the Constitution can be amended by executive action or constituent action, my lord. Now, without bringing the parliament. Therefore, my lord, 367 is a legitimate use so long as Constitution, the rights don't apply.
into the constitution as applicable to the state of Jammu and Kashmir
only.
by CA 48 of 1954.
Correct. So constitution was amended, which was 30, that was 370. You can amend the constitution or you can apply existing provisions.
Under
with-
370, a CO was issued, and which brought in a sense, 35.
Correct. Now, my lord, page 57. Lord, as I pointed out, whenever the situation required it, 370 remained floating. Whenever some changes were required, depending upon the circumstances, they were made through the mechanism of 367. 367 is an interpretation clause. So the interpretation was made. Now, please come to page 57.
Yes.
Sub-article 4 was added in article 367 as applicable to Jammu and Kashmir. This sub-article 4 is not applicable elsewhere. It's only for Jammu and Kashmir. For the purpose of this constitution as it applies in relation to the state of Jammu and Kashmir, references to this constitution or to the provisions thereof shall be construed as references to the constitution or provisions thereof as applied in relation to the said state. Then references to the government of the state shall be construed as including references to the Sadri Riyasat acting on the advice of his council of ministers, because by that time Sadri Riyasat had come. References to a high court shall include references to the high court of Jammu and Kashmir. D. Please note this, my lord. References to the legislature or the legislative assembly of the said state shall be construed as including references to the constituent assembly. They were used interchangeably.
That time there was no legislative assembly.
At that time, there was no legislative.
No, it was, my lord, to be made immediately. Therefore, my lord, in advance, my lord, they must have made a provision. There was none, my lord. This is 54. So there was none, because the constitution was framed in 57.
So in terms of giving representation to the state in other forms, it would require Constituent Assembly to be interchangeably used so that till the Constituent Assembly finalize something, it would not.
No, my lord, another purpose is that till the legislative assembly comes, somebody will have to make laws, other than constitution. They were made. The Constituent Assembly after this functioned as a legislature of Jammu and Kashmir also. And they made other laws also. I have given the list.
It was primarily to ensure enforcement of 370 articles or clause 1, which power was vested with the legislative assembly. So they vested it with the
Constituent Assembly, so that laws can be made by the Constituent Assembly. Otherwise, my lord, Constituent Assembly is not a law-making body in that sense. Of course, my submission is that Constitution of Jammu and Kashmir is at par with a legislation only. It's not, my lord, a kind of a constitution as we understand, my lord, as a document of governance. Yes. Comes to page 59. Look, these are the laws made. I'm not reading, it's not necessary. I'm sorry, my Lord Justice call is conferring. Lord, these are the laws which were made by the Constituent Assembly, acting as a legislative assembly of Jammu and Kashmir. Page 59. Page 59, up to, my lord, page 60. But your lordships can consider noting here that exercise of mechanism under Article 367 to make changes in 370 is undertaken 4 times, which, my lord, I'll come periodically. And whenever some body was not available, the successor body was named. Can I? I'm sorry.
Yes.
I'm sorry. I thought my lord, the Chief Justice is writing.
Yes, sir.
But this exercise or use of mechanism under 367 was directly in issue in Damnu judgment.
Yes.
And it is approved by, my lord, your lordships, my lord, speaking through the Constitution bench. But then comes Puranlal Lakhanpal, my lord. I am not reading it because I don't think anything turns on that either for me or for the other side. It would not render any assistance. It just records the history. That's all, my lord, which we have, my lord, already given. Now, your lordships, my lord, kindly see page 62. The State Reorganization Act comes. It does 2 things. One, Part A and Part B states are clubbed into one called states. So Jammu and Kashmir ceased to be Part B, but it became a state like any other state. And Part C states became union territories. That is first. I'm sorry, C and D both became Andaman Nicobar was D. So A and B became states and C and D became union territories. We are not concerned with that right now in this matter. Second was the identity of princely states was completely abolished. Till then, till 56, the Raj Pramukh was the erstwhile princely ruler. This was abolished. That now, henceforth, it would be the governor appointed by the President of India. The President who is responsible to the Parliament and the Parliament who is responsible to we the people of India. So now, no Raj Pramukh, who is the princely state. He can be appointed as a governor. That's one thing. Some of them were appointed, but not by virtue of they being a member of that lineage in the princely states. But this happened. But at this stage, Article 238 was repealed. Rather omitted, not repealed, but it was omitted by 7th Constitutional Amendment. Your lordship,
So, another thing.
But please come to page 63 only for one date which is relevant. I'm not reading anything.
Page?
Page 67, 63, 17/11/56, the constitution of the state of Jammu and Kashmir is framed. The document called Constitution of Jammu and Kashmir is framed. That's all. Thereafter, straightway, my lord, I have, my lord, given excerpts from the debates which essentially says that Jammu and Kashmir is an integral part of India. I don't think that is something which is not required to be labored much. Therefore, I am not skipping.
Nobody does that also.
Yes, no, therefore, I am skipping that. Please come directly to page 67, my lords. The second use of the mechanism under Article 367. Your lordships would recall, in the first use, the Honorable President said Constituent Assembly and Legislative Assembly are used interchangeably. But at this stage, the Constituent Assembly ceased to exist because the constitution was framed. Therefore, please come to, my lord, page 67.
This is CO 56, right?
Yes, my lord. CO 56 dated 26th February 58. It was required in 58 because of a constitution of Jammu and Kashmir being framed and constituent assembly ceasing to exist, and because of the State Reorganization Act. Please see, my lord, at page 67 bottom, T is deleted. He read reference to the legislature or the legislative assembly of the said state shall be construed as including reference to the constituent assembly of the said state. Because the constitution was framed, constituent assembly ceased to exist, and therefore, my lord, this clause was amended. And E, the term Raj Pramukh was replaced by the word governor because of the State Reorganization Act. Now, Raj Pramukh system has gone.
Yes.
Phraseology used was governor henceforth from this.
Yes, henceforth it was governor.
But the phraseology used to head of the elected government as prime minister did not cease with this.
I beg your lordship's pardon.
Chief minister used to be called the prime minister there.
Yeah, that went, my lord, after Sadr-e Riyasat itself. It became Sadr-e Riyasat. Prime Minister went.
Went after that. Only as a matter of sequence of dates I want.
Yes, yes. It became Sadr-e Riyasat, and thereafter, my lord, Raj Pramukh, and thereafter governor. Now it remains governor throughout thereafter. Now kindly see, my lord, page 69. I am skipping the rest, my lord. They are, my lord, kindly see, my lord, first page 68, Premnath call, but the first judgment,
Yes.
it was more on the competence of the Yuvraj. And therefore, my lord, I believe it may not render
Can we
assistance.
just read that para? VK,
Yes,
can we just read
I'll,
that
my lord,
para?
please. The Supreme Court renders its judgment in Premnath Call versus State of Jammu and Kashmir. It's a 5-judge bench, my lord. The issue before the court was the validity of Jammu and Kashmir Big Landed Estate Abolition Act, which was enacted by the Yuvraj in exercise of powers vested in him under Section 5 of Jammu and Kashmir Constitution Act, 1996. 1996 is Samvat year, 1939, the old constitution. The judgment discusses the constitutional history of the state in great detail and at the same time discusses the power of Maharaja under the previous constitution of the princely state. The question before the court was whether the provision of Article 370, sub-Article 1 till the time the Constituent Assembly of Jammu and Kashmir was in session affect the plenary powers of Maharaja in the matter of governance of the state. In this context, the court held that the act in question, which was enacted in 1950, would not stand interdicted by Article 370 and held that Yuvraj was competent to enact the act. The case effectively concerned the issue of legislative competence of Yuvraj when there is no constituent assembly of Jammu and Kashmir. Yes. But in this very proceedings, when there was a request for a reference to a larger bench, in this very petition, Lord, the 5-judge bench, Lord, speaking through my Lord Justice Call, exactly said this, that it may not have bearing on the either side. Now, my Lord, page 69. Now, my Lord, the integration of judiciary. Slowly, my Lord, some provisions came to be applied, truncated, some full, some modified, some with exceptions. But Article 222 was made applicable regarding transfer of judges. Earlier, my lord, till 60, the honorable judges of the High Court were not transferable by the Supreme Court. But the oath was prescribed, and till 2019, the honorable judges of Jammu and Kashmir High Court used to subscribe to this oath. My lord, please see. Oath or affirmation to be made by judges of the High Court. I, Sri So-and-so, having been appointed Chief Justice or a judge of the High Court of Jammu and Kashmir, do swear in the name of God, solemnly affirm that I will bear true faith and allegiance to the Constitution of the state. Though they were, my lord, under an obligation because of Article 1, and they were applying the Constitution of India. But the oath which they used to take was expressing their allegiance to the Constitution of Jammu and Kashmir state. Even the Honorable Chief Justices, my lord, who would be appointed there, my lord, would be taking this oath. That's it, my lord, nothing beyond. Now, your lordships may kindly come to Puranlal Lakhanpal judgment, my lord, where I would read only one para, my lord, of that judgment, because something turns on that, and I will show, my lord, Sampath Prakash thereafter, my lord. At this stage only, my lord. Please come to, my lord, Case Law Compilation, Volume 1. Page 24, my lord. Only para kindly see, my lord, in those
Case
days,
law
what used
compilation,
to.
which one did you say?
I'm sorry, my
Volume
lord.
one, volume one.
Case Law Compilation, Volume 1, PDF page 24. Well, somebody wanted to stand for election to be elected to the House of People, that is Lok Sabha. He filed this petition. Please see, my lord, page 1 and 4. My lord, only two would be relevant, my lord. Am I with your lordships on page 5? My lord, 24? Premnath call, my lord. The petition challenges the constitutionality of a provision in the Constitution Order 54 made by the President under Article 371. The case of the petitioner is that he is registered as an elector in the parliamentary constituency of Delhi. As such, he has a right to stand for election from any parliamentary constituency in India. 6 seats are allotted to the state of Jammu and Kashmir in the House of People, Lok Sabha. Ordinarily, the election to these seats should have been direct election from the territorial constituencies in the states as provided by Article 81(1). And this is what was happening in rest of the country. But the President modified that article insofar as it relates to the state of Jammu and Kashmir by para 5C of the order in these words. Article 81 shall apply subject to the modification that the representatives of the state in the House of People shall be appointed by the President on the recommendation of legislature of the state. No direct election in Lok Sabha. It's like Rajya Sabha. And the contention was, the petitioner contends that the President had exceeded his powers when he made this modification, for he thereby substituted direct election to the House of People by nomination which he could not do. This, it is said, was a radical alteration. But please mark these words.
Yes.
Yes. Now, kindly, my lord, come to para 4. The court says even radical modification is permissible. But even assuming that the introduction of indirect election by this, my lord, your lordships have para 4, my lord, at page 25. May I read with your lordship's permission? But even assuming that the introduction of indirect election by this modification is a radical alteration of provisions of Article 81(1), the question still remains whether such a modification is justified by the word modification as used in Article 371. We are hereby dealing with the provision of a constitution which cannot be interpreted in any narrow or pedantic sense. The question that came for consideration in Delhi Law's case was with respect to power of delegation to a subordinate authority in making subordinate legislation. It was in that context that the observations were made that the intention of the law there under consideration when it used the word modification was that central government would extend certain laws to Part C states without any radical alteration in them. But now this is the ratio. But in the present case, we have to find out the meaning of the word modification used in Article 370 subarticle 1 in the context of the Constitution. As we have said already, the object behind enacting Article 370 subarticle 1 was to recognize the special status of state of Jammu and Kashmir and to provide for that special provision by giving power to the president to apply the provision of the Constitution to that state with such exceptions and modifications as the president might by order specify. We have already pointed out that the power to make exceptions implies that the president can provide that a particular provision of the Constitution would not apply to that state. If therefore the power is given to the president to efface in effect any provision of the Constitution altogether in its application to the state of Jammu and Kashmir, it seems that when he is also given the power to make modifications, please note, my lord, mark, that power should be considered in its widest possible amplitude. If he could efface a particular provision of the Constitution altogether in its application to the state of Jammu and Kashmir, we see no reason to think that Constitution did not intend that he should have the power to amend a particular provision in its application to the state of Jammu and Kashmir. It seems to us that when Constitution used the word modification in Article 371, the intention was that the president would have the power to amend the provisions of the Constitution if he so thought fit in their application to the state of Jammu and Kashmir. Thereafter, dictionary meanings, etc., is quoted. Lord, why I am reading this? Lord, Mr. Nafde urged that this is an obiter and therefore not laying down any law. Lord, in Sampat Prakash, subsequent judgment, again, my lord, the same Lord, numerical strength, 5 honorable judges, reproduces this para, relies upon it as a ratio. It's not an obiter. Lord, let me directly go to Sampat Prakash so that this point is clear. This is not an obiter. This question directly fell for consideration. The petitioner wanted this honorable court to interpret whether there is any power of radical alteration or modification. And this honorable court said, you can even efface a part of the Constitution. Then obviously radical alteration is something which you can do. Now, Lord, in the same compilation, if your lordships can come, the next judgment, my lord.
27.
Yes, madam. Please come to, my lord, page 27. This was a detention case. Please come to para 2. At page 28. Does your lordship not have them? I'll just read para 2. During the preliminary hearing of this petition, Mr. Ramamurthy, representing the petitioner, it was, my lord, a detention case, raised a ground that section 13A of the act, under which, my lord, the local act, under which the petitioner was detained, was ultra vires the constitution as contravening the provisions of article 22 of the constitution. That question was referred by the constitution bench to the court to a larger bench and came before the full court. On this occasion, the court held that in view of clause C of article 35 of the constitution introduced in the constitution in its application to the state of Jammu and Kashmir, the point that had been raised stood answered by the addition of this clause, and unless the clause itself was challenged, the point raised on behalf of the detainee did not arise. In this view, the reference was dissolved and the case has been heard by the constitution bench. They said that till you challenge 35C, obviously fundamental rights under 21, 22 are not applicable to a detainee. My lord, thereafter, my lord, your lordships may kindly come to page 29. Look, this takes care of Mr. Dwivedi's argument, Mr. Dwivedi for the petitioner. No, my lord, on this side also we have Dwivedi.
He is yet to argue anything.
Yes.
That's in a brotherly sense.
Yes, sir. 29. The first argument, my lord, your lordships would find after, my lord, quotation of the section. The first argument was that this article contained temporary provisions which ceased to be effective after the Constituent Assembly convened for the purpose of framing the Constitution of Jammu and Kashmir state had completed its task by framing the Constitution for that state. Reliance was placed on the historical background in which this Article 370 was included in the Constitution to urge that the powers under this article were intended to be conferred only for the limited purpose and limited period until the Constitution of the state was framed, and the President could not resort to them after the Constituent Assembly had completed its work by framing the Constitution of the state. The background or the legislative history to which reference was made was brought to our notice, my lord, that your lordships can, my lord, skip. Then your lordships may kindly see para 5, my lord. My lord, your lordships can, my lord, directly come to 7, my lord. There are, my lord, your lordship gets, my lord, at page 30, at the foot, para 7. There are, may I read? There are, however, much stronger reasons for holding that provisions of this article continued in force and remained effective even after the Constituent Assembly of the state has passed the Constitution of the state. The most important provision in this connection is that contained in clause 3 of the article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as the President may specify by public notification, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. This clause clearly envisages that the article will continue to be operative and can cease to be operative only if, on the recommendation of the Constituent Assembly of the state, the President makes a direction to that effect. In fact, no such recommendation was made by the Constituent Assembly of the state, nor was any order made by the President declaring that article shall cease to be operative. Both things are separately mentioned. Neither recommendation made nor President exercised, meaning thereby the President could have exercised the powers even in absence of a recommendation, since there is no Constituent Assembly. I hope, Lord, I am able to make myself clear that till Constituent Assembly was in existence, recommendation. Even otherwise, President could have done it after the Constituent Assembly ceased to exist. On the contrary, it appears that the Constituent Assembly of the state made a recommendation that the article should be operative, with one modification to be incorporated in the explanation to clause 1 of the article. This modification in so and so. My lord, thereafter, kindly come to the real issue, my lord, that is 14. Para 13, my lord.
13 or 14?
13, my lord, first. The next point urged was that Article 368 of the Constitution having been applied to Jammu and Kashmir with a proviso added to it, there now exists a provision relating to amendment of the Constitution as applied to Jammu and Kashmir under this article, and consequently, while such special provision for this purpose exists, we should interpret Article 370 as being no longer applicable for amending or modifying the provisions of the Constitution applied to that state. This is what was argued by Mr. Nafede. Now, please see what your lordship say. Para 14. I'm sorry, I'll read it further. This argument, in our opinion, is based on a wrong premise. Article 368 has been applied to Jammu and Kashmir primarily with the object that amendments made by Parliament in the Constitution of India, as applicable in the whole of the country, should also take effect in the state of Jammu and Kashmir. The proviso, when applying this article, serves the purpose that those amendments made should be made applicable to the state of Jammu and Kashmir only with the concurrence of the state government, and after such concurrence is available, these amendments should take effect when an order is made under Article 370 of the Constitution. Thus, Article 368 is not primarily intended for amending the Constitution as applicable to Jammu and Kashmir, but is for the purpose of carrying the amendments made in the Constitution for the rest of India into the Constitution as applied in the state of Jammu and Kashmir. Even in this process, the powers of the President under Article 370 have to be exercised, and consequently, it cannot be held that applicability of this article, that is 368, would necessarily curtail the power of the President under Article 370. It was also urged that the power of making modifications and exceptions in the orders made under Article 371D should at least be limited to making minor alterations and should not cover the power to practically abrogate an article of the Constitution applied in that state. The submission is clearly without force. The challenge to the validity of Article 35C introduced in the Constitution as applied to the Jammu and Kashmir on this ground was repelled by this court in PN Lakhanpal versus State of Jammu and Kashmir. Subsequently, the scope of the powers of making exceptions and modifications was examined in greater detail by this court in Puranlal Lakhanpal.
Yes.
And that is, my lord, which I read, para 4, which as per Mr. Nafede was a near obiter, but the subsequent bench treats it as a ratio, relies upon it, and holds the same thing. But please come to, my lord, now just before one line before paragraph 15. I'm sorry. Para, page 34, just above para 15. This decision, your lordship gets, how the subsequent 5-judge bench treats Puranlal Lakhanpal, para 4 of Puranlal Lakhanpal, which, my lord, Mr. Nafede contended is a obiter. This decision being binding on us, it is not possible to accept the submission urged by the council. So Puranlal Lakhanpal, para 4 is treated as a ratio. Then 15. Yes. May not be of relevance. I'll just come back to my written submissions again. That's on the facts. The rest is on the facts of the case. Lord, please come to page 70. Here, parliamentary supremacy.
Then zero of your submissions.
My submissions, my lord. That would be combined submission, volume 3. (246), my lord, was applied with some modification, of course. Lord, CO 66, Article 246, which was originally applied in 1954 with only one clause, was applied with modification that Parliament would have the power to make laws in the Union list and some entries in the concurrent list applicable to Jammu and Kashmir. Article 254 was applied in toto, thereby ensuring supremacy of the parliamentary laws in case of repugnancy. Lord, rest, there are some additions, my lord, which may not be of much assistance, my lord. Kindly come to page 71. Once again, the Lok Sabha, my lord, takes up this issue. And where, my lord, those famous words of the Honorable Prime Minister Nehruji, my lord, are reproduced. Only underlined portion. As a matter of fact, as the Home Minister has pointed out, it has been eroded, if I may use the word, and many things have been done in the last few years which have made the relationship of Kashmir with the Union of India very close. There is no doubt that Kashmir is fully integrated. I repeat that it is fully integrated. The provision eroded. Most of the provisions are applied according to the situation of the day, and it was awaiting of being extinguished right from 64 onwards. Then, my lord, page 72, CO 69, my lord, this provisions of Article 19, subclause 7 was added, and 35C were extended from 10 years to 15 years. My lord, as I have pointed out, my lord, it came to be kept on being extended till 74. Now, my lord, a private member's bill comes before the Parliament for abrogation of Article 370. Please see, my lord, the debate, the underlined portion only, my lord, for brevity, my lord, so that I don't, my lord, waste more time of your lordships. Inder Malhotra, nominated from Jammu and Kashmir, says this: the people of the state have no special liking for this Article 370, which exists in the Constitution, and we shall be very happy as soon as this is omitted. This was the debate, whether it should be omitted, it should be abrogated, etc. Then Hari Vishnu Kamath, he was also a member of the Constituent Assembly of India, a very leading member, one of the members who contributed immensely. That accession is irrevocable and that integration must come very speedily. If that is accepted, then there cannot be two opinions on the question. That article must go. I take my stand so far as this article is concerned on the firm base that now Jammu and Kashmir state is suffering because this article is there, because difficulties are there by created. If this article is repealed, the state will derive some benefits as other states of the Union are deriving from their relationship with the Indian Union. And therefore, it is from that point of view, that Jammu and Kashmir should be as much a beneficiary of the relationship with the Indian Union as every other state, such as Mysore or Kerala or Bengal or Maharashtra or Madhya Pradesh is today. But, and unfortunately today, Jammu and Kashmir is not a beneficiary of this relationship in the same way and to the same extent as other states. Then, my Lord, Shamlal Saraf, my Lord, adds, retaining Article 370 by not bringing the state at par with the states in the rest of the country. What has been happening? Firstly, there is a sort of insecurity in the minds of the people. Secondly, I will say this frankly, in certain cases, local vested interest, some of them may have been my colleagues, want to have the best of everything and want to take advantage of the present situation. Without bringing any communal, sectarian, or any other view into the matter, I will say that purely from the people's point of view, the people of state have suffered. Once these barriers are removed, once they are allowed to function as any other part of the country, the people will very much benefit. But what was barrier for the people was being canvassed and people were being convinced as a privilege to fight for. Then, my Lord, Sri Sonavne in the chair. My Lord was from Jammu and Kashmir, my Lord, in the parliament. Then, my Lord, Sri Sonavne in the chair, underlined portion. There is the non-application of labor laws. In my state, there are lakhs of people working in various forests, handicrafts, and factories, and all the beneficial laws that we have in the center and which are applicable to the rest of the states, as Nandaji knows, as ex-labor minister, that is Gulzarilal Nanda, my Lord, became acting prime minister twice. Labor minister should ipso facto apply to that state also. I have myself been a small labor worker, and as a minister, I was in charge of labor also, and I know the feeling of workers in that state. Every time they say, why do you keep this wall of separation? Let us all get tile benefit as the rest of our countrymen. After all, in labor, where people work, there is no question of caste, color, or religion. Therefore, it is equally important, and I would say forcefully, that these things should apply there also. Then, my Lord D.C. Sharma, my honorable friend Sri Gopal Dutt Mangi has said that Article 370 is a wall. I would say it is not a wall. If it was a wall, I could demolish the wall easily and in no time. It is not a wall, but it is a big mountain which stands between India and Jammu Kashmir. Although we have dug the Bani Hal tunnel and we have done everything else, we have not demolished the mountain yet. I feel this mountain should be blasted with dynamite, with the dynamite of goodwill, firmness, and decision. That way lies the salvation of India, and that way lies the good and welfare of the people of Kashmir. Then, my Lord, at the foot of this page, my Lord, in the debate, Sri Abdul Ghani Goni, the people of Kashmir had decided once and for all, and have decided once and for all, that Kashmir is an integral part of India. Whether there is Article 370 or no Article 370, it is only a provisional provision and a temporary provision in the Constitution which can be removed at any time. But as far as the complete accession is concerned, that is final and nobody can challenge it. Then, my Lord, Mansingh Patel on the next page, 76. I'm skipping the rest. Lord, Mr. Ghoni, my Lord, I'm told, was also a member of Constituent Assembly of Jammu and Kashmir. And thereafter, he was a minister also. Then, my Lord, Mansingh Patel, we have said before the world as a whole that there is no possibility now of plebiscite, and the integration of Kashmir is firm, final, and irrevocable. We continue with this Article 370, thereby showing to the world as if there is still some difference between Jammu and Kashmir and other states of the Indian Union. This kind of maintenance of separate identity of a state creates difficulty for us. Chatterjee, my lord, I am not reading, voices the same sentiment. Please come to, my lord, page 77, Sri S.S. More, only highlighted part.
But,
I am sorry, my lord, my learned friend wants me to.
Mr. Very interestingly, Mr. Chatterjee refers to the statement of Mr. Sadek, who was the.
Yes, my lord, I'm sorry, my lord, I would, my lord, rather read that.
Vice President.
I have,
of National Conference. Vice President of National Conference.
yes, my lord. I have in my extra hand an extract from Hindustan Times dated so and so, which reads thus: the veteran founder Tiger and National Conference leader Mr. Sadiq today confirmed reports of lawlessness and corruption in the administration of Jammu and Kashmir. Mr. Sadiq, I'm told, was the Honorable Chief Minister then.
He took over after Bakshi government.
Yes, madam. Mr. Sadiq, who is the senior vice president of the ruling National Conference, declared in an interview that abrogation of Article 370 of the Constitution was essential for the restoration of normalcy in that state. I maintain that it is today more imperative for the restoration of normal conditions, for the upkeep of democratic life of that state, and for greater cohesion, both of the people of Kashmir and India as a whole. We should not delay any further. What has happened since 29th of November 63 till today, which necessitates that there should be any going back on the solemn declaration that Article 370 must be abrogated and it is essential for restoration of normal conditions in that state. What is heading of this chapter, that chapter? It is in part 21 of the Constitution, temporary and transitional. Therefore, Article 370 was never 77, the last four lines of N.C. Chatterjee, Manoj. Therefore,
Yes.
Therefore, in the very content of this article, there is a clear demarcation, a clear expression of the will of the makers of the Constitution that it shall not be permanent feature, and the President, by a declaration, by a notification, can say that this article shall cease to operate. Lord, why I am reading this, the argument of the petitioner was that once the Constituent Assembly of Jammu and Kashmir is dissolved without recommending anything, it became permanent. I am just pointing out that subsequently also two things are happening. Everyone says it is temporary and everyone expresses the desire. Why is it not being now?
These are views really. These
Correct.
are views on the floor of the.
But, my lord, please see Mr. More's view. He has articulated, my lord, beautifully on that very page. Next, I rise to accord my hearty support to the present bill. I have read article, I'm sorry, they are views. This is how Parliament understood it.
Not
That's-
Parliament, an individual member of Parliament.
My lord, this is how, my lord, nobody disputes that no, it is permanent.
It was not the view of the government of India, at least, because they would have done it then.
No, our my lord, law minister has said, the honorable prime minister has said.
These are individual views which.
What happened to the bill? But
Private member bill, madam.
It was a private.
The private member bill, madam. It's not carried.
what he is reading, Mr. Subban, is the sentiment running across.
But madam, when you read the whole debate, madam, he's only given you parts. The whole debate is.
There will be debates in favor, there will be debates against.
That's what I'm so.
Ultimately, Mr. Solicitor, we have to construe the constitution. We can't really, these are not really expressions of view by Parliament as a collective body.
This is
Right,
how,
if
my lord,
the
it
member
was
says
understood.
something-
That's all. I leave it at that. Now, my lord, kindly see the view of the government at page 78 bottom. 4th December 1964. In continuation of the debates mentioned above in a speech, then Home Minister Gulzarilal Nanda reaffirmed the temporary nature of Article 370. This is the view of the government. There is no wall between Jammu and Kashmir and India. At the most, you can say it is some kind of a movable partition. We can move it on our own. There is nothing coming in the way. This is the view of the government also. I take this opportunity to inform the House that it has been decided to apply the provisions of Article 356 and 357 also to Jammu and Kashmir. Entry 43 and 78 of the Union list and 33 and 34 of the concurrent list are also being made applicable. I skip a lot, then the highlighted part. Therefore, the area of uniformity is being constantly extended and it is being accelerated and expedited. And as I said before, the House would certainly understand from what I have said that anything else which has to be done quickly could certainly be considered and some kind of action could be taken on that. The government assures the Parliament. Then, Hembara, when you have done so much, why don't you do the rest? Sri Nanda, those who have done so much will certainly do the rest.
The concurrent list was made applicable with, of course, modifications by CO 66, right? Just for the sake of CO
Yes.
66.
For the first time, yes, my lord.
That is 26th of September 1963, right?
My lord, sir. Now comes, my lord, third instance of mechanism under Article 367, page 80, my lord.
The substitution, that is what I was asking for a fact only, Mr. Solicitor.
Yes,
It's
my lord.
only in 1965 that the expression Prime Minister changes to Chief Minister. Your list of dates of 10/4/1965.
No, my lord, Prime Minister description went long back.
Please
Sadr Riyasat was changed.
Please read 10/4/1965.
No, your lordships are at page.
Your notes.
Your note.
Oh,
reads
okay, well, your lordships are right. Your lordships are right. Though this act, the expression Sadr Riyasat and Prime Minister in the state's constitution were to respectively be, your lordships are right. It was
I had an impression, I was not sure, that both things occurred.
in the constitution of Jammu and Kashmir.
Kashmir occurred simultaneously.
Your lordships are right. No, I stand corrected. I was, my lord, answering the Constitution of India point of view when it changed, my lord, in 367. But your lordships are right. In in the Constitution of Jammu and Kashmir, Lord, it was simultaneous in 65. Then, my lord, CO 74. So that is page 80. Lord, please see at the foot what changes were made. Lord, CO 367 was the mechanism of Article Article 367 of the Constitution was amended so as to give effect to Article 370. Please see, my lord, AA, this is addition in green. The lordship gets, my lord. References to the person for the time being recognized by the president on the recommendation of the Legislative Assembly of the state as Sadr-e Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office, shall be construed as references to the governor of Jammu and Kashmir. References to the government of the said state shall be construed as including references to the governor of Jammu and Kashmir acting on the advice of his Council of Ministers, provided that in respect of any period prior to 10th day of April 55, such references shall be construed as including references to Sadr-e Riyasat. Then E was already deleted. E was already deleted. I have just kept it here, my lord, as a record for continuous. It was not deleted by this CO. It was earlier deleted, which I have already shown to your lordships. Lord, this change was the subject matter of Muhammad Maqbul Damnu, this particular CO. There is no intention, Madam. Everyone, we were led by eminent people, everyone contributed. There is no, Madam, undermining the contribution of anyone. The only purpose was voting may differ. This was the view consistently explained, and Madam, my only purpose of reading was this is how the country treated it as temporary. That's all. My learned friend may take any other meaning out of it. Everyone contributed, but even 370 must have come with good intention of integrating the nation. The purpose of reading the debate was, and is, my lord, I'm not reading it now, that it was conceived from the beginning as a temporary provision. That's all, my lord. That not to undermine anyone's contribution. Lord, I pointed out CO, and now, my lord, I requested your lordships to allow me to place only 4 paragraphs of Damnu. Your lordship knows, my lord. Case law compilation, my lord, volume 1, 36 at 44. I'll read only the relevant part. Volume 1 compilation, page 36 at 44. But before rising for lunch, when your lordships rose for lunch, I read the constitution order, which was under challenge. Makbul Damnu. Para 19, my lords. Lord, at page 44, your lordships would find Article 367 as modified is quoted. Then para 18 may not be relevant, 19. Lords. Your lordship gets that. May I read with the lord's permission? On November 17, 1956, Jammu and Kashmir Constitution was adopted. Some sections came into force on that date, and remaining sections came into force on January 26, 1957. But nothing turns on that. At the last 2 lines of that para, my lord, order of 1965, under this order, for clause B of clause 4 of Article 367, the following clauses were inserted. Lord, then Sadr-e Riyasat becomes governor of Jammu and Kashmir. Correct, Manoj? Now please come to 21. According to the Attorney General, this is a mere definition inserted for the purpose of the article in accordance with the constitutional conditions prevailing at that time. But it says at that time because 65 was the CO, 65 or 66, but the matter was heard, my lord, somewhere in 70s. Therefore, nothing turns on that. According to Mr. Garg, this is the kingpin of the whole relationship between the Union of India and the state of Jammu and Kashmir. According to him, neither the Jammu and Kashmir Assembly nor the President were competent to impair the functioning of Sadr-e Riyasat and insofar as Constitution of Jammu and Kashmir Order of 1965 replaced the Sadr-e Riyasat by the governor, it is ultra vires. According to him, either there has to be an amendment to of the Constitution of India under Article 368 and Article 370 sub-Article 3, or a fresh Constituent Assembly has to be convened to amend the explanation. Please mark this. This was, my lord, the contention being considered by your lordships. 22. It seems to us that the essential feature of Article 370 subclauses B and D is the necessity of concurrence of the state government or consultation of the state government. What the state government is at a particular time has to be determined in the context of Constitution of Jammu and Kashmir. Please mark this. Lord, I very respectfully, heavily rely on this finding.
Yes.
The explanation did no more than recognize the constitutional position as it existed on that date, and the explanation as substituted from November 17, 1952 also did no more than recognize the constitutional position in the state. So earlier CO is also not taken into consideration. That whoever was in office was recognized by way of an explanation added to Article 367. Then number 24. The learned counsel relying upon Sampat Prakash contended that the only way of modifying Article 370 is specified in Article 370 sub-Article 3 itself. He said that this was expressly laid down by this court in the decision just referred to. We are not concerned with the question whether Article 370 sub-Article 3 can now be utilized to amend the provisions of Article 371 and 2, and therefore we do not express any opinion on that point. We are now not concerned with the amendment of Article 370 sub-Article 1. We are concerned with the situation where the explanation ceased to operate because there was no Sadr-e Riyasat. It had ceased to operate because there is no longer any Sadr-e Riyasat of Jammu and Kashmir. If the definition contained in the explanation cannot apply to the words government of the state, then the meaning given in Article 367(4) as amended will have to be given to it. So if an authority contemplated under Article 370 ceases to exist, it can be replaced by the successor or the closest possible successor under 367.
Yes.
If this meaning is given, it is quite clear that the governor is competent to give the concurrence stipulated in Article 370 and perform other functions laid down by Jammu and Kashmir Constitution. Now, your lordships may kindly come to the last para, 26. It is true that governor is not elected as was the Sadr-e Riyasat, but the mode of appointment would not make him any the less a successor to Sadri Riyasat. Both are heads of the state. But I am not reading this in the context of Constituent Assembly being read in the same mechanism of Article 367 to be the legislature. Now coming back, my lord, to my submissions, my lord, written submissions, volume 3, combined written submissions, volume 3, my lords. I'm sorry, my lord, if your lordships are at the judgment, my lord, can I, only one, my lord, argument, my lord, I left, my lord. Para 28, my lord, I'm sorry. At page 47, I missed that, my lord, I should have read that. This was also an argument, my lord. A similar argument is made before your lordships by the petitioners, my lord. Therefore, I am relying upon para 28 in Damnu judgment, my lord, at page 47. Para 28, your lordship gets, my lord justice. Yes. Mr. Garg drew our attention to clauses AA and B of Article 367(4) as substituted by CO 74 of 66. We have already set them out above. He said that this was an amendment of Article 370, subarticle 1 by the back door, and the President could not exercise these powers under Article 371 when he had not purported to exercise these powers under Article 370, subarticle 3. But as we have already said, the explanation had become otiose and references to Sadre Riyasat in other parts of the Constitution had also become otiose. There were two alternatives. First, either to leave the court to interpret the word government of the state and give it its legal meaning, or secondly, to give the legal meaning in a definition clause, that is Article 367. What has been done is that by adding clause AA and B in the definition is supplied, which the court would have in any event given. Therefore, we do not agree that there has been any amendment of Article 370, subarticle 1 by the back door. Just for completion, 32 on that page. It is also not necessary to dwell on the third point, namely violation of Article 21 and 22 of the Constitution, because it is clear that they are excluded by Article 35C of the Constitution. Now, my lord, coming back to my written submissions. Page 83. Again, my lord, as I had done, I'll skip what is not, my lord, relevant right now and is added only for completion. Page 83. My lord Justice Gawai, my lord, my summary, my respondents' written submissions, volume 3, page 83. Your lordship gets that one. 17/2/1969, Article 248 was applied in a substituted form, giving exclusive power to the Parliament to make laws with respect to the prevention of activities directed towards disclaiming, questioning, or disrupting the sovereignty and territorial integrity of India, or bring about secession of a part of the territory of India, or secession of a part of territory, etc., etc. Lord, this is where the residuary power in a wide sphere dealing with sovereignty was given. Then your lordships may, my lord, kindly come to page 86, my lord. 85 bottom. I am skipping 2 pages, no? 85 bottom. 6/5/1972, Your Lordship has taken. It further expands the residuary power of the Parliament. CO 93. CO 93, the scope of Article 248 was increased, whereby the exclusive power was vested to the Parliament to make laws with regard to the prevention of activities of disrupting the sovereignty and territorial integrity, etc., to also include taxes on foreign travel, inland air travel, postal articles, etc. Then your Lordships may, my Lord, come to page 87. Lord, 28th of August 76, 42nd Amendment of the Indian Constitution come into being. Lord, what was not applied was the word socialist and secular. I have already pointed out. The word integrity was not applied and fundamental duties were not applied. Then March to July 1977, the President rule is applied, is imposed. My Lord, I have given the note. My Lord, please note, my Lord, as a matter of fact, till 2023, governor's rule under section 92 of the Jammu and Kashmir Constitution have been imposed 8 times, and president's rule, I'm sorry, my Lord, your Lordships are at page 87 at the foot of the page. Till 23, governor's rule under 92 of Jammu and Kashmir Act 8 times, and president's rule under Article 356 3 times. Lord, under 92, there is a stipulation that it cannot exceed 6 months. Therefore, then, my Lord, next date, 9/5/78, 44th Amendment of the Indian Constitution was brought in. The note, the non-application of the said amendment resulted in non-application of clause 4 of Article 22, which provides for major protections against preventive detention, which were not applied. This is what they lost, and this is what they started getting from 2019.
Article 22 has not been notified yet, right? So for the rest of the country, it has also not been notified as yet.
No, it is, Madam. Is it?
22-4 is not notified.
4 to 7 is not yet.
Wait, I'll check up. I'll check up.
What take a noise case?
But you can't issue a mandamus to notify a constitutional amendment.
Then in Article 359 related to suspension of enforcement of rights conferred by Part 3 during emergencies, the words except Article 20 and 21 inserted by 44th Amendment not applied. Hence, an absurd situation arises where in Jammu and Kashmir, even Article 20 and 21 can be suspended during emergencies, while in rest of the country it cannot be done. That's all, my Lord. Emergency provision is a provision of 44th Amendment, my Lord. There is, and learned friend may not feel angry about it, my Lord. That's the provision which is not applied. That's the only purpose of pointing out. Then, my Lord, next, 4th June 85. It modified Article 248 as it applied to the state by empowering the Parliament to make law for prevention of terrorist activities. But please see the note only, that's relevant. This indicates the government of India was taking steps to maintain law and order in Jammu and Kashmir. Notably, the modification to the union list included the term disrupting sovereignty and integrity of India. Then, some provisions with regard to scheduled tribe and in the state where, my Lord, but that were in a truncated way, not for election purposes, etc. Nothing turns on that, my lords. Then 30th of July 86, my lord, page 89. The said order,
In
my lord,
June
this is your
1985, June 1985, entry 97 was also applied, though confined to this area.
Yes. My lord, that was made applicable, it was expanded, my lord, it was applied in 69. 1969. I'll just, my lord, if your lordship comes to page 83, it is 17th February 1969, where entry 97, your lordship would find the first para, last second line. Does your lordship get, my lord, the Chief Justice gets, my lord?
No,
Lord, page 83, date is 17th February 69,
yes,
CO
yes.
85, the first para, last line, my lord. Further, entry 97 of the union list was applied in a modified form
Right.
dealing with the above subject.
Right.
Then, my lords,
Now we go back to your.
yes, my lord. Page 89, my lords. The said order was order issued during governor's rule. My lord, this is important, and the notes would be more important. Several COs are issued during governor's rules also. That has been a consistent practice under constitutional convention. The said order issued during governor's rule modified Article 249 in its application to the state to state that the Rajya Sabha, by passing a resolution with over two-third majority, could empower Parliament to make laws on any matter specified in the resolution, bring a matter which is not enumerated in the union list or concurrent list. So, my lord, effectively all residuary powers with two-third majority. And including state list, my lords. And this was done during governor's rule. Come to page 37, page 90.
COs in fact were amending Article 356 because that prescribes 3 years.
I'm sorry,
These were then extending the president rule as prescribed in the Article 356 because the period prescribed is 3 years maximum.
But it kept on being extended by the
But
parliament.
COs, it was extended from 3 to 4, 4 to 5.
It can go up to 7, Manoj, because parliament will have to then extend it. Because situation was, Manoj, it was an extraordinary situation. During that period, it was at the.
No, I'm not on that. I'm not on that. That the power to amend was excised in terms of 356, notwithstanding the proviso to
Yes, your lordships are right. That was the.
368, notwithstanding the proviso to.
Yes.
But the bodies challenged? No, they were never challenged.
No, not yet. Lord, your lordships are on page 90.
Page 9, yes, I'm on page 9.
Yes. All 4 constitutional orders were passed under the president's rule. And president rule lasted over 6 years in the state. So thereafter, I have given what Mr. Sibal has already taken your lordship through. Blue is Mr. Sibal's note, my lord, list of dates. Then, Lord, 1/3/2015, the Legislative Assembly of Jammu and Kashmir was elected and oath was administered by the members. The tenure of the assembly was 6 years, which was to expire on 1st of March 21, the last ministry. Even thereafter, my lords, can we come to the next date, 6th of July 2017, CO 269, the said constitution order harmonized the tax administration of the state of Jammu and Kashmir with the GST regime operating in the rest of India. Correspondingly, entry 82 of union list was applied with modifications. This ensured even economic unification, so to say. Then, my lord, 2017 is the judgment in Santosh Gupta, my lord, which I will read only 2 or 3 paragraphs, a little, yes, a little later. Please come to, my lord, page 94. 19th June 2018. The then Honorable Chief Minister resigned. Correct, Manoj? And 20th June, 2018, the governor took the decision to exercise the powers under section 92 of the Jammu and Kashmir Constitution. Now, my lord, couple of things your lordships may note at this juncture. This is appointment of imposition of governor's rule in June 2018. No contemporaneous challenge by anyone, either a political party or any elected member or any citizen, anyone. The first challenge comes after 14 months when the impugned action of 5th and 6th August 2019 is taken.
Can you invoke section 92 after Article 356 was made applicable?
No, Article 356 came subsequent. Yes, yes.
Nobody's raised that issue.
But subsequently 356 comes. So if there was, yeah, I understand Malad, the query. Even if there was an irregularity which is caught subsequently by 356. After 6,
I'm still saying that.
but your lordships are right. Malad, that is the reason why ultimately I would show Malad the constitution of Jammu and Kashmir required to be repealed because it can never coexist. Once you apply the entire constitution, you cannot have a situation where there is a separate document of governance operating. It was, my lord, according to me, it's a separate argument, a piece of legislation, but your lordships are right. They have been directly under 356. Your lordships are absolutely right.
And Solicitor, when you say the contradiction, the very fact that you invoke section 96, 92,
92.
and not 356, you're accepting that both of them can coexist.
Qua 92, yes. Otherwise, my lord, there are several provisions which I'll be able to demonstrate. But, my lord, in any case, that's my lord, a separate submission on that, my lord. Why? How Jammu and Kashmir constitution would not exist the moment, my lord, 370 sub-article 3 is invoked. But your lordships are right.
You can argue, but other way also, there are other arguments available to make that argument,
Correct.
or that submission.
My lord, thereafter, on 21st of November 2018, the Constituent Assembly is dissolved. Pardon me, sir?
Legislative Assembly.
I'm sorry, Legislative Assembly, my stand correctly. Well, Legislative Assembly was dissolved. No challenge to this contemporaneously. Most importantly, my lords, I'm sorry. Today, there is no challenge to the dissolution of the assembly. The petitions which were filed after 5th and 6th
That
of
resolution also takes place in the Constitution of India as applicable to Jammu and Kashmir.
your lordships are
In
Your
terms of
Lordship,
section 53.
it should have been, my lord, under 117. The petition which Mr. Sibal argued Muhammad Akbar loan is a petition filed by two members of parliament belonging to National Conference, Muhammad Akbar loan and one another member. No challenge either to the governor's rule, president's rule, or dissolution of legislative assembly. One IA is filed by the former chief minister, argued by Ms. Ramkrishnan, in 2022, IA for impleadment. Yes, I'll just double. That is IA number your lordship wants. No? IA number is 154272 of 2022.
15.
154272 of 22 in writ petition civil number 1099 of 19. That is item 501 on board, the lead petition, Shah Faisal. Now not my lord, Shah Faisal, but correct, my lords? So, no political party challenges either governor's rule or president's rule or dissolution of assembly contemporaneously. Dissolution not challenged at all. Otherwise, your lordships are aware, my lord. Your lordships are disturbed even at the middle of the night that now we are ready to forge an alliance and we are ready to form a stable government. Because there were several arguments were made on that. That how can the assembly be dissolved like that? I'm just, my lord, pointing out the hollowness of that argument. But before I go further, Lord, I must deal with one submission.
So writ petition civil 1099 of 2019 did not challenge these three things.
My lord, writ petition is by
Did not challenge the governor's rule, president's rule, or before that.
no, my lord, I must point out the governor's rule is challenged, but after 14 months, when
After in
5th and
1099.
6th of August 2019, when that was must be being drafted, it must have been advised that you have to challenge the main imposition. That appears to be the case.
So the governor's rule was challenged.
Challenged after 14 months.
Then obviously the president's rule would have been also challenged.
Yes.
It's bound to be.
Yeah,
And
bound to
the-
be.
And dissolution of the legislative assembly is also challenged.
Is not challenged.
Is not challenged.
Is not challenged, still not challenged. In any of the petitions, till date.
Till now, none of the petitions is challenged.
Yes. None of them.
And that's in terms of section 53(2).
Yes. And, my lord, the petition argued by Mr. Sibal, which was which is number 1099, loan, Abdul.
That was 10.
Muhammad Abdul loan, my lord, which was by NC, my lord, National Conference, not even president's rule or governor's rule under challenge. Well, I have a list. I have the list, my lord. I'll just show that list, my lord, to your lordships. Where is that list?
True of fact, what is the governor's rule was challenged through a PIL filed in this court, dismissed. There was a PIL filed in this court, challenges government's rule, was dismissed by Justice Gogoi. And I'd be very happy if this court were to say that because all this was not challenged, the entire process that is adopted is constitutional.
Where did I argue that, my lord? Why
I'd be very happy if this court were to say that.
My lord, where did my learned friend, my lord, why is he presuming what I am going to argue?
Since you are talking about it.
No, I am talking about it because half an hour of a political kind of an argument was made. How can you dissolve the assembly like this? What are the powers of the governor, etc.?
Constitution bench of this judge, of this court has said you can't do it.
Correct, but you can't argue it without the challenge.
I have never made a political argument in this court and your lordship knows about it. Not a single political.
Lord, if there is no challenge and if you raise a plea that there was, the governor should never have dissolved, it becomes a political argument. It's not an argument based to suppress.
Taking your point that Mr. Sibal's writ petition, there was no challenge to president's rule, governor's rules or the dissolution.
Yes, and dissolution not in challenge in any of the petitions.
That we've got.
So, my lord, that question your lordships need not go into. That's the, my lord, respectful submission. And my learned friend is right. So please, if you don't mind.
Paper book 501.7, in fact, the counter affidavit has a listing of all the prayers of all the
I
petitions.
was going to say that, please allow me. I have prepared a list and placed it, my lord. This is the submission in support of my, my lord, plea that your lordship need not go. Because substantial time was consumed on this argument. Therefore, my lord, I am, my lord, laboring this point that it was not necessary. My lord, please come to, my lord, volume 501.7, paper book 2993. My lord, the prayers are quoted.
50?
Which document file are you saying?
Which document?
Paper book.
The main paper book, my lords.
1.7.
Page?
Page 2993. Why would I not point out something which is in my favor and I have placed with my reply?
Folder.
2993.
There's various item numbers.
Incorporated all the prayers with writ petition numbers. This one.
2993 is the
2993, my lord, is the page number. PDF page 2993. Your lordships have seen the chart. These are the only prayers before your lordship. And that too after 5th and 6th of August 2019, after 14 months. And I have, my lord, also narrated a chart showing the pleadings also.
But we have petitions where everything is challenged except the dissolution of the Legislative Assembly.
Correct. No, my lord, there are petitions.
There are petitions challenging the imposition of governor's rule, the imposition of president's rule, and but according to you, no challenge to the dissolution of the Legislative Assembly.
Correct, my lords. But one factual clarification. In some of the petitions, even that the governor's rule is not under challenge. For example,
there are some petitions where there is.
Yeah, yes,
so
but
we'll
some
have to deal with it
petitions
anyway once it is raised.
to,
Even in
to have a challenge to governor's rule.
Governor's rule was challenged in most of these petitions post the president's rule.
Post the
All the petitions post the decision. That is why
What
I,
Mr. Sibal said, there was an earlier petition filed which was discussed.
yes, well, that's what, my lord, I have pointed out, my lord, in my summary of submissions, my lord. Please see, my lord. That is, my lord, at page,
If there were no actions on fifth and sixth, we won't be here. We wouldn't have challenged anything. We are challenging the actions under those provisions.
no,
That's
let,
all.
Mr.
I'm
Sibal.
just saying. we wouldn't
No, no,
be
I
here.
am also, whenever interrupt, I am just saying, but don't do that.
It's not-
That's why the rejoinder stage is always there. I understand your discomfort, but what can you do? What can I do? वो जो,
I mean, I understand you.
not, PIL. Not PIL, it was not a PIL. I'm sorry, it was not a PIL. My learned friend, my lord, possibly not correctly briefed. It was a PDF 250. Take, my lord, PDF 250. I have, in my written submissions, my lord, I have done this. One MLA challenge, it was not a PIL. Please see, my lord, the order of this honorable court.
Let's finish with argue about this.
And kindly have a look at, my lord, at PDF 250.
Same paper book.
Yes, my lord.
Which paper?
No, I'm sorry, volume paper. No, I'm sorry, written submissions paper.
You are taking us back to volume 3?
No, my lord, the same volume 3 of written submissions.
That's what I'm saying.
Yes, there, PDF page 250. This Gagan Bhagat was not a PIL petitioner, he was an MLA.
BJP MLA.
We argue, anyway, my lord, we learn from my lord, senior, my lord, I will not say anything more than that.
Yes, I know.
I am only arguing a matter, my lord, I have no political,
Yes, let it finish then.
My lord, I have nothing, this is a constitutional point for me. Your lordship gets that order, my lords?
This was a petition challenging precedent's rule.
Yes. No, I've this.
Governor's rule.
Dissolution, I'm sorry, dissolution,
This was against what, challenge dissolution or the governor's rule?
dissolution,
Dissolution.
dissolution.
Therefore, they've not included that prayer in any of these petitions because that has attained finality.
But that's what they came to know when I say in my written submissions. They were not aware of it. They have not mentioned that we have not challenged because it is affirmed by the Supreme Court. I'm sorry, ma'am. The Lordship said that we have heard, we have seen the record, and we dismiss the petition. Therefore, I am not going into the details. Otherwise, my lord, I can show details also. But there are reasons, my lord, why it is not challenged. My lord, when you don't have a case on the floor, you don't challenge it. That's as simple as that. But let's not go into it. Why they have not challenged it? It's definitely not because this petition was filed and dismissed. Because none of the petitioners say that this petition was filed, heard by this court, and dismissed, and therefore we are not challenging it. They came to know possibly only when I pointed out in my written submissions. So far, it was not on record. Now, Lord, page 95, 1912-2018. Lord, proclamation under Article 356.
This is about the list of those.
Yeah.
Lord, here, my lord, I must answer one question. Lord, suspension of proviso to Article 3, my lord, that was an argument. Lord, there are two arguments. The argument was advanced with a nuance that this was a device to bring certain legislative enactments or certain parliamentary actions by suspending the provisions of the article, the proviso to Article 3, namely the reorganization. Like that was the allegation. Correct, my lord, your lordship recollects that. As a matter of fact, right from the inception of this country, whenever president's rule is imposed, proviso to Article 3 is state. We have studied each and every proclamation issued by the president under Article 356 with regard to each and every state, not Jammu and Kashmir. Proviso to Article 356 is suspended in every case. And please have a look at, my lord, the chart which I have, my lord, placed at page 227 of this very file, my lord, of this very volume. As if we did something surreptitiously because some sinister plan was in the mind. This happens right from the inception. The first president rule was in Kerala in 1957. Since then, my lord, we have studied, and my lord, we have the learned AG also has the volume, my lord, if your lordship would like to see that. But I have said so. So please come to page 227 of this very volume, my lord. Two 26 minutes. So please see, Andhra, Arunachal, Assam, Bihar, Goa, everywhere, my lord, suspended. The lordship would come to page 9, clause 9, erstwhile state of Jammu and Kashmir. Twice, 86 and 90. On both the occasions, the proviso to section Article 3 was suspended. There is a reason, my lord, why this format is used. It's not to do something surreptitiously. Lord, in SR Bomai, the law laid down, and I'll come to that, the law laid down is that the legislature cannot function without council of ministers. When that is the position here, additionally, the legislature was dissolved, but otherwise also, whichever provision of the constitution mentions something to be done by the legislature, that provision is suspended. That's the format to be used, being used from the beginning. 1977 was the first use of 356, 59, I'm sorry, 59. Mr. Nambudripad's government was removed and the president's rule was imposed. That was the first and perhaps the most controversial imposition of president's rule. There also suspension of 3 proviso was there. We have the notification if your lordship would like to see that. The first use of 356. This is the idea. This is the purpose. Whichever constitutional provision says use of some legislative act by way of making law, by way of views, by way of recommendation, those provisions stand suspended during president's rule. It was not with a view to do something which they claim to be a fraud on the constitution. That's the respectful submission. Now coming back, my lord, to page 95. Lord, once the president's rule is imposed, your lordships are aware Article 356 requires that it needs approval of the parliament. Both the houses will have to approve it. Lord, last but one date, 28th December 2018. A resolution approving this proclamation issued by the President on 1912 was passed in Lok Sabha. I have given my counter affidavits number. This is not a fact in dispute. 3rd January 2019, approving this proclamation issued by the President on 19/12/2018 by Rajya Sabha. Correct, Manoj? Now, Manoj, during the President's rule, there are certain steps taken, Manoj, with a view to infuse confidence amongst the people. Manoj, there were situations, Manoj, which were alarming situations. Everything won't come on record, Manoj. Pulwama happened in February 2019, etc., etc. And the government will have to take certain proactive steps. Now, that first step is 1st of March 2019. But this is a well-considered administrative decision-making, keeping in mind several factors: national integrity, sovereignty, security, border issues, internal issues of the particular state, etc., etc. Please see, using the power under Article 371D, CO 271 was passed, which extended. Please allow me to delete 61st Amendment. That's a mistake. And kindly delete in your Lordship's copy also. It was applied earlier. Nothing turns on that, my lord, either way. It is a simple mistake, but just to put the record straight. Then 77th Amendment and 103rd Constitutional Amendment, providing for reservation in favor of economically weaker sections of Jammu and Kashmir and for providing reservation in promotions. Now, please note this. It may be noted that this was during the currency of President's rule, similar to impugned CO 272. However, the same has not been challenged till date. Further, the power under Article 371D to issue CO has been exercised during President's rule on 6 occasions in history. The note 1. The extension of this amendment, this is the relevance. Please note this, something may turn, something may not turn, but it may satisfy a lordship's conscience. The extension of this amendment to the state reinforces the fact that in terms of social justice policy of reservation, the state of Jammu and Kashmir is governed by Constitution of India. Acceptance of social policy of the Union further means that Jammu and Kashmir does not and did not have a sovereign right to determine the social policy at odds with that of the Union. Thereafter, my lord, President's rule is extended on 22nd July 2019, and thereafter please directly come to page 97. But one fact, my lord, from Mr. Sibbal's notes, my lord, I may show. Mr. Sibbal, my lord, in blue, has said that several questions were being put to the minister. Are you going to change 370? Are you going to take some steps? And the minister concerned, my lord, used to say that we'll act according to the Constitution. That's all. But please see, my lord, just above 28th of June 2019, the question is put post Pulwama and the answer. Please see this. The question, Srimati so-and-so, 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 ask question number so-and-so, 1. Your lordship gets one? Charging?
Referring to page?
I'm sorry, page 97. Lord, but for this, Lord, e-filing, but this kind of matter, my lord, it was very almost impossible, my lord, to effectively argue.
other way around.
Other way, just turn it around, no?
Turn it.
Yeah.
Lord, page 97, date 26th June 2019, from my learned senior Mr. Sibbal's Lord note. Srimati so-and-so asked question number 485 from the Minister of Home Affairs as to A, the viewpoint of the government regarding Article 370 and 35A in respect of Jammu and Kashmir. The policy government is working on to control the terrorist activities and details thereof. Then Sri Reddy, my Lord, MOS Home. At present, Article 370 is a part of Constitution of India. Under the title Temporary Provisions with respect to the state of Jammu and Kashmir, and Article 35A is contained in the Constitution, application of Jammu and Kashmir Order 1954, issued by the President under 370B. And C, the government has adopted a policy of zero tolerance towards terrorism. Effective response is given by security forces to counter terrorism activities in the state of Jammu and Kashmir. In order to combat activities of terrorists, several steps have been taken, including strengthening operational grid, enhancing coordination among security agencies, effective retaliation of terror acts. Please mark this, brother. And this comes, my lord, immediately, strengthening the ROP to protect convoys, etc. Correct, my lord? I leave it at that, my lord. I don't wish to elaborate it further. My lord, since the President's rule was extended, my lord, it had to again go for approval. Both the houses, my lord, respectively on 28th June and 1st July, my lord, approved the extension of the President's rule. Now comes, my lord, an important event. Again, my lord, to ensure that those who are staying in border areas are having a sense of security, social security. 1st July 2019. It is critical to note that on the same day, Jammu and Kashmir Reservation Amendment Act was passed by the Parliament, exercising powers as the legislature of Jammu and Kashmir. Your Lordships have seen Article 256 1B, that when President's rule is there, the Parliament exercises the powers of the legislature. This enactment was passed. Considering the strategic and security concerns in mind, the Jammu and Kashmir Reservation Amendment Act was passed by the Indian Parliament. This fact is mentioned to show that, like in past, the Parliament has exercised legislative powers of Jammu and Kashmir Assembly under Article 356 1B. Prior to, this is important, prior to the aforesaid Act, some category of reservation was available only to border areas of Kashmir Division. Border areas of all divisions, that is Kashmir, Jammu, were facing frequent attacks and shelling, and resultantly more hardship. Regimes prior to 1/3/2019 somehow confined the reservation benefit to borders areas of Kashmir Division only. Look, there are several steps which are required to be taken in view of several circumstances which the nation faces. And these are the steps as precursor. Lord, kindly see now PDF page 229 of this very compilation. Lord, I have said that this has been the practice and a constitutional convention throughout. Whenever there is a President's rule, the Parliament exercises the power of the legislature as contemplated under Article 356 1B. In all states,
Yes.
my lord, page 229. My lord, I'm not reading, but I have taken, my lord, till date, whichever are the acts passed by the parliament, acting as a legislature of the state during president's rule, the list is given, my lord. But there are total 248 such laws passed, my lord. So far. West. Happens.
248 laws.
Two, my lord, just go to 242. I'm sorry, 243, my lord. There is something which would, my lord, require your lordship's attention, my lord. 242, my lord, I'm sorry. At 243, my lord. Lord, this is, I'm showing in case of Punjab. Lord, the most important part of any legislative transaction is passing of the budget. Budgets are passed by the parliament on behalf of the states, acting as a state legislature. Come to, my lord, the important part, 243. And I'll point out, my lord, what is the relevance of showing this. In case of Punjab, your lordships would find item number 31, the Punjab Reorganization Bill. Your lordship gets that?
Yes.
My lord Justice, my lord, 240. But during the president's rule, the parliament acting as the legislature even reorganized the state of Punjab. Something which happened here, my lord. Lord, Punjab was divided, bifurcated into Punjab and Haryana. Chandigarh was carved out as union territory, and some part of erstwhile Punjab went in Himachal. These were the four bifurcations, my lord, which took place by Punjab Reorganization Act passed by the Parliament acting as a legislature. So, my lord, it is not uncommon or it is not something which has happened for the first time that you can elevate the argument to the level of a constitutional fraud.
But this must be a reorganization act under Article 3.
Yes, I'll come to that, my lord. I'm coming to, because I'm right now, my lord, pointing out that suspension of proviso to Article 3 is not unusual. Whenever provision is suspended and precedent rule is also imposed, the parliament acts as a legislature. My lord, and this, my lord, when I my lord, make my submissions on Reorganization Act, I'll, my lord, also point out this Reorganization Act was challenged on this very ground before Delhi High Court.
Yes, Punjab,
Yes,
Punjab,
Punjab
Haryana.
judgment. My Lord Justice H.R. Khanna's judgment. And it was also challenged before this honorable court and Mangal Singh, I'll point out 5-judge bench judgment. This very Reorganization Act. Now coming back, my lord, I'm sorry.
Yes.
Lord, Lord, kindly come to 10. Lord, before I take, Lord, now, my Lord, I am on the last leg of this written submissions, my Lord, namely,
But Mr. Solicitor, if the powers of the legislature of the state under 356B can be exercised by Parliament, then what is the constitutional necessity of suspending the proviso to Article 3?
so that legislature, if present, if not dissolved, may not do anything. But this is, we are dealing with a case where the legislature was dissolved. But suppose it is in suspended animation. The legislation remains, the legislature remains. It might assemble and pass a resolution.
To be very frank, except in the case, possibly the case of Punjab, I don't think Article 3 would have been invoked in many other cases. But as a matter of convention, what has been happening is whenever 356 is imposed, going by your submissions, proviso to Article 3 is also suspended.
Suspended.
Because the power under Article 3 is different from the power of legislation.
Correct. No, my Lord, my Lord, point out 356, my Lord, kindly just taking a
That's
little
what was
detour.
highlighted was power under Article 3 is different from the power of which is conferred of making legislations, making or enacting laws.
That's where, my Lord, I would like to say something if your Lordship takes 356. Taking a slight detour, my Lord.
No, it says to calls about functions.
It says the powers of the legislature.
Powers.
No, not just powers to make laws.
Correct, it's broader, it's
All
broader.
powers.
All powers, and now please see proviso to subarticle, to Article 3. Proviso to Article 3. Provided that, I'm sorry, sir. Yes, brother. Provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views thereon. This is the different power of the legislature than power to make laws. So even this power in the present case was exercised by the Parliament. Now, my Lord, before I take, my Lord, the last leg of my...
Otherwise, in the absence of the suspension of the proviso, what would happen was that the Parliament is exercising all the powers of the legislature of the state. It would give its views on it, and it would also enact the bill.
Yes, ma'am. Yes, ma'am. That's the constitutional.
So that's your answer to the challenge that there's duality is missing in this case, because you say when Article 356 is invoked and we have been and the proviso is suspended, there are instances in the past wherein it was this argument of duality was rejected.
Yes, my Lord, I can, my Lord, take directly your lordships too.
Or we'll come to that. You go in your own way.
No, otherwise, my Lord, Justice H.R. Khanna's judgment on this as a Delhi High Court, my Lord, in Delhi High Court is directly on the point. And explanation and my Lord, the interpretation of Article 3 by a constitution bench in Mangal Singh. That also, my Lord, concerned Punjab. This very reorganization, which was under 356 and the power exercised by Parliament as a legislature. But in Punjab, incidentally, even views were not taken of the Parliament as a legislature, saying that the assembly is suspended. So straightway, the reorganization bill was passed. As a reorganization, my lord, this is interesting, and I'll show that judgment. What happened was, in the erstwhile state of Punjab, my lord, for example, there were 85 seats of MLAs. Now some portion goes, so 85 became 70. The remaining 15 challenged them. That how have you taken away our right to continue as members of the Legislative Assembly? And the number was lower than even minimum prescribed for any assembly to have. And then the question arose about Article 4, that you can make incidental provisions which might even amount to amending the Constitution but would not be treated as amendment of the Constitution. Constitution bench of your lordship. But since, my lord, we are on this, let me, my lord, show Justice H.R. Khanna's judgment, my lord, because your lordships have just seen Article 356 and Article 3. My lord, kindly have a look at, my lord, Volume 1, my lord, compilation Volume 1. That is a separate argument, but at this stage, my lord, I'll just show these two judgments, my lord, just to. Lord, it's marked, my lord, in my written submission also. Lord, it's easier, but rather than going to page 167 of this very compilation, a very.
Now you are back to the original one.
Written, yes, ma'am. So my lord, your lordship may not have to shuffle through. Yes. Lord, what I have done is, for your lordship's convenience, I have quoted the para. Of my written submissions, my lord. That is joint written submissions, Volume 3.
'67, right?
167, my lord. On reading Article 3 and Article 174(1) of the Constitution, along with above proclamation of the President, it is seen that the President had suspended the power of Governor to summon the House or each House of Legislature of the state, which by itself prevented the state legislature from meeting, and also suspended the state legislature from meeting, and also suspended so much of proviso to Article 3 of the Constitution relating to the reference by the President to the legislature of the state. It will thus be seen that the power to summon the legislature of the governor having been suspended, no occasion could thereafter arise during the period when such suspension was in operation for the legislature to meet for the purpose of expressing its views on the bill. Here it was dissolved. The bill to be introduced in Parliament affecting the area, boundaries, or name of the concerned state. This would be the direct result of the suspension of the power of governor to summon the legislature of the state, even without suspension of so much of the proviso to Article 3 relating to the reference by President to the legislature of the state. However, in order to make the matter clearer, the operation of so much of proviso to Article 3 had also been suspended by the President in view of the clear power conferred by Article 356 1AB to declare that powers of the legislature of the state shall be exercisable by or under the authority of Parliament. It enacted Act number 31 of 66, by which all powers of the legislature of the concerned state of Punjab, to make laws were conferred on the President. We can find no warrant for the contention of the petitioner that what was transferred by means of Article 356 1B of the Constitution was only the legislative power of the state legislature, but not the power to meet and express its views as contemplated by the proviso to Article 3 of the Constitution. But as my lords pointed out, that the word power is wider, which includes power to make law, but all powers, give recommendation, expressing views, etc. Three of the according to the petitioner, Article 356(1)(c) only enabled the president to make such incidental and consequential provisions as appeared to him to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provisions of the Constitution to any body or authority in the state, but not to make provisions which were not both incidental and consequential. This was not the contention. This argument of the petitioner would appear to have no validity for two reasons. Firstly, the expression incidental and consequential may be read as incidental or consequential to suit the context, that this is a permissible mode of construction if the context so requires. It is well settled. It will be sufficient to refer. Then the judgment is when N can be read as or your lordships may skip. Para 10.
Mr. Solicitor, you have referred to the fact that there's a practice, a constitutional practice, that during the operation of a proclamation under 356, the proviso to Article 3 has been suspended. And you have said that that is obviated by the reason that if you don't do so, and the legislature is only in a state of suspended animation and not dissolved, the legislature may conceivably meet to express its view. To obviate that, Parliament, the presidential proclamation does this. But none of this constitutional practice cannot obviate the legality of what is done, right?
Here, in the present case, even the views are taken, but views are given by the Parliament as a legislation. In Punjab, that was not the case.
So Parliament would then give the views
to itself.
And it would also enact the legislation for reorganization.
Yes, but that's the inevitable consequence.
But would that really be consistent with the federal document?
I will show that. It does not destroy federalism at all. I'll be able to satisfy your lordships. I'm just, since we are discussing this, I have not taken up the point of state reorganization.
All right, but you're saying that...
Yes, but since we were answering, I was answering the proviso to Article 3, which came with 356, I'm reading this.
All right.
Para 10, it can hardly be denied that the dispensing with the need to consult the views of concerned state legislature was itself a direct consequence of the legislature being unable to meet for any purpose whatsoever during the period when governor's power to summon the legislature was itself suspended. The petitioner does not advance his case in any manner, therefore, by laying stress on the expression incidental alone in Article 356(1)(c). Secondly, the petitioner cannot seek to derive any assistance from the English decisions which he quoted in order to show that what he contended was the restricted meaning given to the said expression, etc., etc. It could even have been that
it refers to the earlier incident in the case of erstwhile state of Travancore and Cochin, probably also under 356. May not have been challenged in that case.
Not to my knowledge, it was not.
Paragraph 95, it refers to.
Paragraph
5.
Novel situation has been taken place in past. Punjab was passed. Further, the erstwhile state of Travancore, Cochin was also reorganized during Article 356. In both the cases, the views were not taken.
Possibly it takes into account sometimes there may be a breakdown of constitutional machinery within the state when the reorganization itself
is the solution. When there is a, kindly appreciate, why this, I'm sorry, kindly, consider this. When the reason for imposition of the precedent rule is such that to bring that state out of the situation which resulted into imposition of precedence rule, maybe state requires to be reorganized. Then, the position cannot continue as it is. The President of India can take a call that the only solution of the problem is reorganization of the state. And your lordships are, my lord, the arguments repeatedly advanced was that there is a retrograde step. We were brought down from state to UT state. I will show, my lord, from the reorganization. It's a state for all purposes. It's a state with legislature, with only power of police with the president. It's a detailed state reorganization. Everything was factually wrong, that my consolidated fund has gone, my representation in parliament has gone, my election voting in president's election is gone. Specific statutory provisions are made. GST council is gone. Well, these are the arguments which were. So, I am coming to that reorganization. The UT, Lord, is essentially as much a part of federal structure as any other state. In a given set of facts, Lord, your lordships have, Lord, I don't want to jumble up, Lord, my submissions, but there are, Lord, submissions. What would be the contours of your lordship's examination once your lordship finds that 356 exercise was not to be faulted with? What happens thereafter? There would be a restricted scope of judicial review. That's what Bomai has said. It's a narrow compass doctrine. No? Your lordships are aware. Lord, I'll take your lordship through them. But here, to obviate that also, the views of the parliament situations where it is necessary that for some time this remains under union as union territory. And the Honorable Home Minister on the floor of the House has said that this is a temporary measure. Ultimately, it will become a state. But that's a separate argument. But I'll come to that. Lord, now I may, my lord, complete, my lord, my written submission, my list of dates, my lord.
What page?
My lord, I was at page 102. My lord. But before that, my lord, I wanted your lordships to read one judgment. My lord, 102. Let me, my lord, complete this stepwise, my lord. My lord, step 1, your lordships have seen, my lord?
No, we were going to read that actually, right? We were just going to read that actually.
Yes. No, your lordships are at step 1, my lord.
We are now at step 1.
Yes, my lord. Please see, my lord. As a first step, the Honorable President issued CO 272 by the said constitutional order issued under 370 subarticle 1, that is D. The President applied all provisions of the Constitution of India and superseded all previous constitution orders by which selected provisions of the Constitution of India were made applicable either with or without modifications.
This one second.
I'm sorry, my lord, Justice Call gets, my lord.
Point number 1.
Point number 1. Step number 1. As a first step, the Honorable President issued CO 272 by the said Constitution order issued under Article 370 subarticle 1. The President applied all provisions of the Constitution of India and superseded all previous constitution orders by which selected provisions of the Constitution of India were made applicable either with or without modifications. And 2, the Honorable President applied Article 367, your lordships have seen it has been applied 4 times in past, of the Constitution of India as modified under the said order, in which modification was made in Article 367 subarticle 4. Please see, my lord. At D. This is the exercise which is, my lord, approved in Damnu. D. In proviso to clause 3 of Article 370 of this Constitution, the expression Constituent Assembly of the state referred to in Clause 2 shall read Legislative Assembly of the state. This is the first step. My lord, when I explain this, my lord, I'll assist your lordships that in absence of an assembly, Constituent Assembly, my contention in law is that the president is free to take a call, even without recommendation, but I'll come to that little later. Step 2. After having applied the entire constitution with modification as stipulated in 367(4)(d), as reflected above, because we had to, my lord, save 367 because that's the mechanism we have used. Reflected above, the parliament after CO 272 was placed before it, undertook the following exercise in its capacity as the legislator of the state. Then, my lord, Rajya Sabha recommended to the president under Article 370, sub-article 3 as under. Now, Rajya Sabha as a legislative assembly recommends, please see, my lord, the bottom, that this house recommends the following public notification to be issued by the President of India under Article 370, sub-article 3. Please see, my lord, the next para. All provisions of this constitution as amended from time to time without any modifications or exceptions shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in Article 152 or Article 308 or any other article of this constitution or any other provision of the Constitution of Jammu and Kashmir or any law, document, judgment, ordinance, order, bylaw, rule, regulation, notification, custom or usage having the force of law in the territory of India or any other instrument, treaty or agreement as envisaged under Article 363. But simultaneously, on bill being sent to Rajya Sabha under proviso to Article 3, Lord, which according to me, I can safely argue not necessary in absence of the legislature views. I'll show the Mangal Singh judgment. But it was placed before the Rajya Sabha as a legislature. First step of legislature, because second is Lok Sabha. Rajya Sabha expressed its view to accept Jammu and Kashmir reorganization bill as under, that the President of India has referred the Jammu and Kashmir reorganization bill to this house under the proviso to Article 3 of the Constitution of India for its views, as this house is vested with the power of state legislature of Jammu and Kashmir as per proclamation of the President of India dated 19th December 2018. This house resolves to express the view to accept the Jammu and Kashmir reorganization bill. Simultaneously, on the bill being sent to Rajya Sabha under proviso to Article 3, the President, the Lok Sabha expressed its view. After Rajya Sabha, Lok Sabha, so that it whole becomes the legislature. They also, my lord, accepts the thereafter, my lord, Rajya Sabha passes Jammu and Kashmir Reorganization Act 2019 after views of, my lord, both the houses. Now, your lordships may skip the note and kindly come to page 106 bottom. Next day, 6th of August 2019. The lordships have seen, my lord, the recommendation of the Rajya Sabha acting as a legislature under Article 370, sub-article 3. Now it comes before Lok Sabha. On 6th August 2019, again the Parliament commenced its proceedings, exercising its function as Legislative Assembly of Jammu and Kashmir. The following legislative activity took place. Lok Sabha recommended to the President under Article 370, sub-article 3, not same, I'm not reading it, recommending to the President that you apply all provisions of the Constitution as was recommended by Rajya Sabha. And Lok Sabha passed Jammu and Kashmir Reorganization Act because the views were expressed the previous day. So both the views and act, it becomes an act namely Jammu and Kashmir Reorganization Act, and both the recommendations which now culminates into, Lord, 263, CO 273, I'm sorry, 273. Lord, please see page 108. Further, in the appendix to the bill, a comprehensive schedule contained the list of central laws made under the Union list and the concurrent list by the Parliament, which would henceforth be applicable to the Union Territory of Jammu and Kashmir and Union Territory of Ladakh. The amendments have also been carried out to the existing state laws made under the state list by the erstwhile state legislature in order to bring them in line with all provisions of the Constitution of India. So they become now Constitution compliant. It is critical to note that the said Reorganization Act applies an already existing constitutional provision, that is Article 239A, to the region. It is stated that the same counters the assertion of the petitioners that it was in breach of federal structure. It is stated that Article 239A itself is a part of federal or asymmetrical federal structure and cannot divorce the concept from the landscape of Indian constitutional law. Article 239A, applicable to Puducherry for decades, is one of the ways of maintaining federal relationship between region and center and cannot be said to be arbitrary and irrational. Then step 4 and the last step, CO 273. President issued CO 273 in exercise of powers under Article 370 sub-Article 3 of the Constitution as amended by CO 272, declared that Article 370 would cease to apply with effect from 6/8/29. This is what is impugned. Thereafter, my lord,
Mr. Solicitor, this may be your answer as far as Ladakh is concerned, but converting J&K into a union territory, what is being argued by the other side is downgrading.
I must meet with them.
That argument, number one. Number two is Article 356, the maximum tenure as prescribed is 3 years. We have crossed those 3 years.
At the time of, my lord, I'll answer that, my lord, but 2019 we have not, and thereafter, my lord, we are in a different regime.
No, I know. Now, as a union territory, that 356, that part will not apply because union territory is something different.
Is, my lord, therefore, my lord,
But if it was not a union territory, then
it
that
would have crossed. It would have crossed by now, but for the intervention of 5th and 6th August 2019.
yes, that's
Yes. Lord, for your lordship's convenience, I have prepared, my lord, a chart. This is only section and the article and how it changes. It would be for quick reference, my lord, if your lordship permits. It's not nothing new. Nothing new, my lord. But 367 application, my lord, is little confusing if we read from various pages. Therefore, my lord, we have just made a common kind of a 3-page chart.
as far as 367 is concerned.
Only 367.
367, because there was some deletion also in 367.
Therefore, my lord, please, my lord, it won't take more than 5 minutes, my lord. Kindly pardon me, my lord. This, I think, better to have the physical copy, my lords, because it's larger. Lord, left-hand side is the Article 370 as it stood on the date of Lord, Constitution coming into force. Correct, my lord? Right-hand side is as on 17/11/52, CO 44. Lord, the change made under 370 sub-Article 3. Please see the color part. My lord, your lordships, I think, my lord, the Chief Justice is ahead of me, my lord.
Yes. the
Yeah,
first-
always so, my lord, but even
No,
in
but
this chart. my lord.
Explanation, right? Explanation.
Explanation, for the purpose of this article, the government of state means, my lord, this is replaced by Sadr Riyasat. Please see.
Right.
Person for the time being recognized by the President on the recommendation of the Legislative Assembly as Maharaja of Jammu and Kashmir, acting on the advice of Council of Ministers for the time being in office under Maharaja's proclamation dated so and so. The person of for the time being recognized by the President on the recommendation of the, this is edit, the green part is addition, my lord. Green part, kindly, my lord, if your lordships can consider writing green part is addition. But please mark one thing, though, my lord, at that date, 17/11/52, the Constituent Assembly was in place. In 52, Constituent Assembly was in place, but only Legislative Assembly, my lord, was used while defining the state.
Right.
When there is a state, Legislative Assembly of the state, President on recommendation of Legislative Assembly of the state as Sadr-e-Riyasat of Jammu and Kashmir. This is the first change.
But this was done pursuant to the recommendation given by the Constituent Assembly.
Correct. I have said so, my lord, in my written submissions as well. My lords are right. Thereafter, my lord, page 2, Lord, this is as on 14th May 54. The second change takes place.
Just one, this would be, this amendment which came as a result of, this is under Article 370, Clause 3.
First,
The first exercise.
first exercise.
This is,
Now-
this is under Article, Clause 3 of Article 370.
The first one, yes.
Because at that time, Constituent Assembly was there.
Yes, was in force.
So they then, the
Recommended.
recommendation resulted in the amendment to the constitution, it got carried forward. Words which are not pre-consulted.
May 1954, that is CO 48.
Yes, my lord. The entire green part is added, my lord.
Under Article 367.
Yes, my lord. My lord, only D we have highlighted in yellow to, my lord, show to your lordships, my lord. I have already emphasized that reference to the legislature or the legislative assembly of the state shall construed as including reference of constituent assembly. So inclusive definition. So they were used interchangeably. Otherwise, my lord, this entire green part is added in 54 and its effect is given, my lord, on the right hand side.
Right.
It is the same thing and therefore I am not reading it, my lord. I have given the effect of the 367 exercise. Then, my lord, coming to page number 3, it is again, my lord, under 367, where D, your lordships would find in red is deleted. Correct, my lords?
Right.
The reference to legislature or the legislative assembly is deleted and, my lord, green is added. What is deleted, my lord, is in red. Raj Pramukh reference goes, my lord, in 58 because of, I have pointed out, Reorganization Act, etc. and, my lord, Article 238, my lord, being repealed. Reference to a governor shall include reference to the governor of Jammu and Kashmir, provided that in respect of any period prior to the 10th day of April 55, such reference, that is for the past period. So now, now comes the governor, because Sadr-e-Riyasat ceases to exist, and therefore the governor. Right hand side, I have given effect to this amendment.
CO 56 came in after the constitution was framed in
Correct.
Jammu and Kashmir, after 26 January 1957.
My lords are right.
So therefore, the reference to the Constituent Assembly is done away with in the Article 367 interpretation.
But exercising the mechanism under 367. That's the, Lord, I wish to highlight. Otherwise, that's the two reasons. A, Constituent Assembly was not there, and governor because of state reorganization. Now, my lord, AA is the new addition. My lord, this is 66. My lord, this is the left-hand side on page 4 is what the AMNU judgment, my lord, approves. That 367 can be used for this purpose. AA is addition, reference to the person for the time being recognized by the President on the recommendation of Legislative Assembly of the state as Sadr-e-Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And, my lord,
But Sadr Riyasat had already gone, right?
yes, yes, ma'am.
So then what was the need for bringing this in 1966?
No, I'm sorry, Sadr-e-Riyasat went here.
Oh, it went
I'm
here,
sorry,
that's
it
right.
went here. Earlier, it was removed from B, 4B. I'm sorry, B, it remained, it went in E. E. Now it goes from B as well.
Earlier, the amendment was Sadr Riyasat acting on the advice of the Council of Ministers. Earlier, it was individual capacity, then it became acting
Yes.
on the advice of Council of Ministers. Here now, the Sadr Riyasat is replaced by Governor.
Governor acting on the aid
Right.
advice. Yes, ma'am. Now, my lord, the last one at page 5, Lord, which is done by CO 272, the impugned one, my lord, page 5. The proviso is added. The exercise which was undertaken so far under 367 was again undertaken for the purpose of Jammu and Kashmir. For Article 370, the word Constituent Assembly was replaced by the word Legislative Assembly. Same thing, because Constituent Assembly ceased to exist, it became Legislative Assembly now. And my lord, the rest I have, my lord, already explained.